I like to mention with a concern about others. I have already taken the item 28. Here I have to file an additional affidavit. So lawsuit can come some time. I have already informed them and they have no objection to it.
Okay. Mr. Sisti, learned counsel for the complainant with consent from the other side, press for listing the matter after.
I mean, immediate after vacation notice. First week.
Immediately after reopening of the vacation, so as to enable him to file one additional affidavit. Fair allowed.
May I please? Well, item 16. I'm led by Mr. R.P. Sharma. Also, I have taken consent. Maybe taken on 11 December.
Eleventh. Okay. Mr. Rashid, learned counsel for the petitioner with consent from the other side, press for listing the matter on 11th. Fair allowed.
Private mention for district fiction measure pertaining to the salary, not given a salary order. It was last year.
Immediately after reopening, before vacation, not possible. Take a date from him.
Lordship, similar pair lordship, salary matter lordship.
Salary
So if
matter,
possible
okay.
on
First
Monday.
week of January. First week of January.
Lordship, then after Bihu lords, yeah, first week of I will get this.
Okay. Take a date from him.
Similar matter.
Okay. Okay.
May it please, your lordship. To mention item number 9, 11, 12, and 13, my lords, motion matters. Kindly be taken up in the first week of January, my lords. There been some developments in this matter. So, lordship, kindly fix it.
Item
immediately after-
number 10, 11,
My
12,
lord, 9, 11, 12, and 13.
9, 11.
9, 11, not 10, my lords. 9, 11, 12, and 13.
Okay. On the pair being made by Mr.
Yes.
Jai Singh, learned counsel for the petitioner. Rest allege the matter after
On the first week of January, my lords.
first week of January. Okay. Fair allowed.
My lord, this matters may kindly be tagged up so that
Mr. Singh further submits that all these four writ petition may be taken together. Fair allowed.
okay.
Pension matter. Next week may not be possible. Okay. Admission.
Admission matter. January.
Contempt case for motion for Friday lordship, motion, oblige your lordship.
Number 24. As for the recording, that's fine. Oh my God. We have filed an additional affidavit today. Call for the recording.
May it please your lordship, I would like to make a mention for listing of a writ petition for admission on 10th December 2025. The
That
urgency is that I have been not paid the arrears salary and also I'm facing
after vacation,
financial-
immediately after reopening. Take a date from him.
Your lordship, I was to mention item number 17, we have filed a reply affidavit in response of the affidavit in opposition by respondent number 2 and 4, because need to be on record today.
Today.
May I please your lordship? Lordship, I beg to mention for listing a matter regarding provincialization of service lordship. It was last posted on 3/11/2025. Friday.
No. After vacation. After vacation.
Mention item number 25. Additional affidavit.
May I please, lordship? In respect of item number 43, we have filed an
Item number
43, lordship.
43.
Okay.
Repetition matter relating to service matter. Last listed on 14 and already filed their affidavit.
In admission column,
My lord, admit.
January 1st week.
Oblige.
Lord, similar prayer, Lord, regarding provincialization, not listed for last 3 months, Lord.
But you could have mentioned it earlier,
Lord,
not immediately before the vacation.
last week of before the vacation, Lord.
Hmm.
Make an attempt, Lord. Some
No,
urgencies, there few persons are going to be retired, Lord. That's
when?
why. Month of January, Lord.
Are you sure?
It's and I have from their physical appearance, Lord, I am sure, Lord. Very pathetic.
No, is it sure and certain that on
No, no,
that we
no.
will be
Lord,
able to
out
dispose of the same?
of 10, 15 petitioners, only few, Lord. 2, 3 may be retired, Lord. Determined, Lord.
Hmm. So immediately reopening, after reopening. January. Okay. Fifth.
With the concern of the other side, I beg to mention item number 42 of today's list, Lord, sir. Mr. S. Sharma is appearing. The matter may come up on Friday, Lord, sir.
S. Sharma
Yes, Lord, sir.
is appearing for?
5. Applicant in the IA, Lord, sir.
Okay. Okay. Mr. Your good name? SK Dekar, Learned Counsel for the petitioner. Respondent number 5.
Applicant, Lord, sir.
Respondent number 5 in the IA number 3569 of 2025.
Lord, sir, in the rate petition, we are the respondent 5. IA with
Applicant.
Yeah.
Okay.
Your Lordship, the interim
Uh,
will be concluded.
Respondent number 5 in the WPC number 4879 of 2025 and applicant in IA number 3569 of 2025. With consent from the other side, press for listening the matter after
Lord, Friday, Lord.
next Friday.
Yes, Lord.
Okay.
Please, the Lordship, my lord, I beg to mention item number 3, my lord.
Hmm.
Regarding the jurisdiction of the petitioner, my lord. I need some accommodation on Friday, my lord.
Friday.
Yes, my lord. I am trying to find judgment, my lord.
Okay, Mr. DP Borda, Learned Counsel for the petitioner. Press for listing the matter on Friday. Very lot.
Maybe I beg to mention one listing, my lord. Admission matter, my lord. My service was provincialized, my lord. Subsequently, it was a turn.
Hmm.
So before my vacation, any day, my lord.
Vacation not possible.
My lord, my service was provincialized. Subsequently, it was done, my lord. My lord,
In
from
which call of
2020,
motion or admission?
admission matter, my lord.
After vacation,
My lord,
5th January.
kindly before vacation, any day, my
5th
lord.
of January.
My page, your lordship. Lordship, order start from page number 15 and relevant portion at page number 40, lordship. Direction was issued to pay 30 salary as well as area salary, lordship.
Heard Mr. Sharma, Learned Counsel for the petitioner. This petition under Section 11 and 12 of the Contempt of Court Act 1971, read with Article 215 of the Constitution of India. Is referred by the petitioner for non-compliance of the judgment and order dated 16/7/2025 passed by this court in WPC number 2516 of 2006-18. Peruse the petition and the documents placed on record and also peruse the order dated 16/7/2025. Let notice be issued to the contemners returnable in 4 weeks. They be taken by registered post with AD and also by usual process within a week from today. Let's the matter after 4 weeks.
Lordship.
So what is the instruction?
Lordship, here there is a notification from personal department which is barred for partner's appointment. So we have returned the file to seek this Lordship because here as per the notification, they are for appointment Lordship. But the notification has also been tagged. So we have sent it because there was we have sent the notification order to all the departments keeping the names of all the people who are entitled for compassionate appointment. So their names were not present over there. Now a cabinet decision will be required. That is as per our instruction. So the views of the personal department have been sought. We have returned the file back, Lordship. The endorsement is also tagged over there. OM issued by the personnel department is also closed over there, Lord.
Okay, do you do one thing, you furnish a copy to her? She will obtain instruction.
Lordship.
Heard, Mr. Heard, Miss,
P. Soria.
Learned Counsel for the petitioner, and Mr. A. Soleha, Learned Standing Counsel for the Finance Department, and Miss P. Das for respondent number, respondent number 120. Person to order dated 3/12/2025, Mr. Soleha has obtained up-to-date instruction, written instruction, and placed the same on record. A copy of the said instruction be furnished to the Learned Counsel for the petitioner to obtain necessary instruction. Let's list the matter on next Monday.
Lordship, I have only one copy, Lordship. That copy I can just use it.
Okay, okay.
May I please? Lord, this is Lord, sixth round of litigation. Now we have challenged the Lord, resolution. Lordship will find at page 101. Lordship will find page 101. Minutes of the meeting of the joint committee for Punjaban service under the provisions of the so and so act, dated 25/9/20 in the office of this chamber, so and so. Now, at page 103, we are agreed, my lord, resolution number 6. Resolution number 6, my lord, Lordship will find second para. Madrasa, so and so was not provincialized due to the late submission of the under the Provincialization Act 2000. Again, there is no mention of the date in the district scrutiny committee report. Now the committee has decided to complete the enrollment of the students from this so and so DB as well as trace out scrutiny committee, submit the report to the level scrutiny committee. Now, this is absolutely not absurd. Record. Now, Lordship, kindly see the records. We are having the records on RTA application, my lord.
No, Mr. Mondolo, whether you are implementing the joint committee as party in this proceeding? Joint committee?
Joint committee.
Are you implementing them as party?
They are met party respondent.
Yes, chairman, not the joint committee as a whole.
Entire members. Entire members, Lordship, kindly see. Entire member. Joint committee has no business. In fact, under the act, no provision of the joint committee. They are acting without any authority of law. We have made them party respondent. Respondent number 5, 6, 7, and 8.
Okay.
Now, one is the chairman, and rest are 3 are the members of the committee. Now,
So, okay, Mr. Sisti.
Yes,
While the act has not provided any such committee, on what basis such committee was constituted?
there is a provision, I have to take instruction. Right now, I couldn't recall it. Can issue notice, I will come with affidavit.
No, is it provided in the act? Is it provided in the act?
No,
Act is okay, but there is some provision I think important. I'll have to take the specific instruction.
the Act, section 13 is the DLC and SLC. Issued by the government. Now, Lordship, kindly see what they are lying, my lord. I see your Lordship, the original minutes, my lord. Lordship, kindly see page 58. They are saying there is no date. This is absolutely absurd.
Page number 50?
Page 58. My lord, we have given the respective, my lord, type copy. Now, Lordship, kindly see page 59. The original DLC, my lord. In the top, Lordship will find
50?
page 59.
Yes.
This is the first minutes of the, my lord, DLC. That Lordship will find in the top 62 2019. Now they have stated in the minutes, my lord, there is no date in the DLC. Page 59. Now this is in respect of our school, Lordship will find at page 60, continuation, my lord, serial number 26. Page 60, the entire minutes, my lord, of the district. Page 60, serial number 26. Nasir Mandal Memorial High Madrasa. Then Lordship will find page 61, this recommendation part. And not teaching staff. After that, Lordship, kindly see another re-verification. Page 80. Page 80. Page 80, my lord. This is dated 2023. Page 80. 3/4/2023. Here, Lordship will find serial number of the chairman ka member secretary place so and so received from DSC e-verification against the claims of the candidate for provincialization of and suggestion from the member. Now we are concerned, my lord, number 1. Applicable teaching staff of Nasir Mandal Memorial High School. Now, here number 6, Lordship will find after the review of the record, the district scrutiny committee will examine the eligibility of the candidates in the next meeting. Now, next meeting, Lordship, kindly see. Next best, my lord, we have annexed page 81. Page 12/4/2023. Then you will find, my lord, we are concerned, my lord, the serial number 5, the school documents, including the documents of the Nasir Mandal Memorial High School, have been examined and found in conformity with the Act 2017 for provincialization of the teaching staff. The post of headmaster is lying vacant. The following teaching staffs are found eligible for provincialization. These are the, my lord, clarificatory, my lord, made by the district committee. Now, finally, Lordship, kindly see at page, my lord, page 86. Page 86. Page 86, my lord, left hand side, Lordship will find High School. These are the name, my lord, they are the petitioners. Now, Lordship will kindly see the earlier order passed by the Honorable Court. Find at page, my lord, 90. Page 92, kindly see, my lord. 45, Lordship, kindly see, at page 95.
Okay. Mr. Sisti, you see on the other day, on the prayer being made by the standing council, 4 months time was granted to provincialize the service of the petitioner.
Yes.
That was on instruction. He submits. But now this joint committee. So here direction is to provincialize their service. Now to reject the same, whether the joint committee is the appellate authority of this court.
Provision.
From where they got the authority? Not rejected.
Rejected. Not a committee, they have to obtain enrollment of students from the ASSCB. They want to further verification. For further verification. they
No,
will
no,
not take-
if it is not provided in the act, how can they verify it again? Because on that day, that order was passed on the submission made by the standing council for the department. Hmm?
It is 94, my lord. They, my lord, stated.
Mr. Mondal,
Madam.
we will list the matter tomorrow.
Madam.
Let him obtain instruction.
My lord.
How the joint committee was constituted, under which provision of law,
Yes.
what is their legal status?
My lord.
But
Wednesday-
are you challenging the constitution of the joint
No,
committee here?
yes. They have no authority jurisdiction.
Not that.
We have in our writ petition.
But in the prayer, only that, taking care of the increase resolution number 6. Committee, they have not said it. Till then, no one has challenged this committee lordship in any petition.
But some
No, local
observations were made by the coordinate benches of this court regarding this joint committee. Some judgments are there.
But Honorable Apex Court also
You,
held.
you try to find it out.
Yes.
Hmm.
Honorable Apex Court held, my lord,
But tomorrow
we
will-
need not challenge the, my lord, committee. Because if it is, my lord, to the provision of the act. Any notification.
Wednesday, lordship.
Wednesday. Okay, all right,
I will-
Wednesday. Heard Mr. M. Mandal, learned counsel for the petitioner, Mr. S.M. Sesni, learned standing counsel for the respondent in secondary education department. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the resolution number 6 of the joint committee. 6 dated 25/9/2025, adopted by the joint committee, comprising of respondent number
5, 6, 7, 8, 9.
5, 6, 7, and 8. 7 and 8. It is to be noted here that by impugn resolution number 6 of the minutes of meeting held on 25/9/2025, the joint committee has decided the joint committee has held that there is no mention of that in the district scrutiny committee report, which is doubtful. And the committee has decided to obtain enrollment of students from ASSEB Division 1. And also as well as to trace out when the district scrutiny committee submitted the report to the state level scrutiny committee. Mr. Mandal, learned counsel for the petitioner, submits that this constitution of the joint committee is illegal and illegal as it is not provided under the Act and rules. And they have no authority to verify. The report submitted by the state level committee. And moreover, Mr. Mondal, drawing the attention of this court to the minutes of the meeting of the district level committee, which is annexed to the petition as annexure number 9, shows that there the date is mentioned as 16/2/2019. 16/2/2019. And as such, the observation, the impugn resolution is illegal and arbitrary and therefore it is contended to interfere with the same. In view of the submission advanced by Mr. Mandal Learned Counsel for the petitioner, it is provided that Mr. Sisti shall obtain instruction as to whether as to under which provision of law the joint committee is constituted, and he shall also obtain instruction in respect of the annexure number 9, where the date of minutes of the meeting is mentioned as 16/2/2019, whereas the committee in the resolution has observed that there is no mention of that in the district scrutiny committee report, which appears to be contrary to the record. And on such count also, Mr. Sisti shall obtain instruction. List the matter day after tomorrow.
If I can obtain that copy of the order,
Okay.
it will be beneficial.
Okay.
Develop.
Let's shall furnish a copy of the order to Mr. Sisti during the course of the day. Yes,
please, Your
Mr.
Worship.
Avedin?
This is as far as a council, this is my first case coming against the order of the Education Tribunal, my lord. In this R5 against whom I have come, my lord, was appointed in the year 1992, Venture School. As your lordship is aware that all the ventures schools are.
No, that's all right, but Mr. Avedin,
Yes, my lord.
you say the tribunal is manned by a judicial officer. And it is well settled that against the order of a judicial officer, writ petition under Article 226 is not maintainable. It is passed by a district judge as a tribunal.
Yeah, normally,
Is it maintainable?
There is nothing mentioned and there is no appellate forum. So this is the only forum available, my lord. There is no appellate forum.
Maybe, but under Article 226.
My lord, over here, my lord is hinting that it's 227.
227 court has the jurisdiction. But while alternative remedy is there,
There is
then
no alternative
227 will not lie.
after the
What is
tribunal.
provided in the act.
After the tribunal.
Because a tribunal is not the final authority and cannot be.
Yes, my lord. So there is no alternative remedy after the tribunal, my lord.
Are you sure?
Yes, my lord.
But then that may be under Article 227.
No,
May
then,
not be under
my lord,
226.
but over here, there 227 and 226, your lordship is aware that there is the basic difference is that over in 227 there was nothing wrong by the tribunal. It was under the division bench of the decision the tribunal was formed, and tribunal normally pass the pass the order.
Tribunal is constituted as per the
Honorable
Act.
Supreme Court order in TMA file of the 2012. From there, that it is state government law. It came from the Honorable Supreme Court.
Is it incorporated in the act?
Yes.
Section 19.
Section 19.
Section 19.
My lord, in this book, my lord,
Page number?
okay.
Section.
Yes. Section 19, actually, 2000. Page 24 of this book.
Okay, let notice go at this is, but the question of maintainability will be kept open.
And there's a notification also in the group topic.
No, that's all right, but what is the appellate forum then?
Appellate forum. There's no appellate from itself. You have seen in the, they have come against that order of the tribunal. A lot of cases are pending.
That is also under 226. What happened, I'll just, if you after 11 Act were enacted for giving this benefit of professionalization to the teachers. It is a beneficial legislation. Case piled up, my lord, only in respect of the venture educational institutions. Then the court opined that this venture the teachers are coming. That can be taken care of in the district level if we designate a tribunal. So that was the perhaps the understanding in the division bench, and my lord, ultimately the division bench in Abdul Ghafoor's case. Full bench in Abdul Ghafoor's case, they have decided that yes, for ventures teacher on certain issues, it can be from to the Educational Tribunal. Thereafter, the state government by notification designated the district judges as the Educational Tribunal, my lord. But over that stop, it's not that after the tribunal, what is the appellate authority? And my lord, as your lordship is aware, my lord, otherwise, unless there is specific alternative remedy, 26 is the other remaining forum, my lord.
Notice would go at this.
No, but there is my lord, there is one aspect. Notice and only one not go into the other merit unless and until they come up with the saying that my reputation is not maintainable. I believe that I have already gone through that. My reputation is maintainable, my lord. Its status quo as and today shall be maintained.
No, your pair was rejected. Your pair for provincialization was rejected by the tribunal.
No. My service, I am the petitioner. My service was provincialized under the Act of 2011. The person I approached the tribunal because of this honorable court. He was terminated from the service in the year 2003. When the Act of 2011 came, for the first time he knocked the door of this honorable court in the year 2011. The 2011 said yes, government should look into this matter. The IS to look into the matter. The IS looked into the matter. In the meantime, my service was provincialized under 2011 Act with effect from 2011 Act under 1/1 from 1/1/2013. Then he approached this honorable court again, saying that, my lord, only one thing your lordship would remember, he was terminated in the year 2003. That means he did not go under the proceeding of 2011 or 2017 for getting the provincial. Then this honorable court said no. There was a remark by this honorable court that you are saying you are covered by 2003 rules. That is wrong, because the venture schools are covered by the 2006 Act under the Non-Government Educational Institution Act. So with that remark that it was asked him to go to the tribunal. The tribunal, my lord, the minute, the interesting aspect, one thing is that the order was of 10/6/2016 by this honorable court.
23/9/2016, the act was declared ultra virus. One was asked to approach the honorable 90 days. He with confirmation, he did not approach. Ultimately, he approached on 3/2016. But the act has gone on 23/9/2016. And new act came in the year 2017, 11 April. So during this period, when there was no act, nothing, he approached the court without getting the clarification from this honorable court. Not just the tribunal took the clarification where to approach, under 2011 Act or 2017 Act. But the discrepancy, only one line alone, with that, because my service, I have been specialized, the school, there is an order of reinstatement where, I don't know, because the school is already merged with the base school and our services are already confirmed. But would your lordship be pleased to see only 109, my lord, page 109. My lord got it. My lord, number 5, would your lordship be pleased to see, my lord, number 5. Page 109. The resolution of the school managing committee dated so and so is set aside and there will be no effect of the from today. But which resolution, my lord? There are 3 resolutions. That is, I have said in the petition, present
Okay,
petition.
we will consider this aspect at the time of hearing.
Yes, my lord.
Let notice go at this business. Let notice go at this business.
One more line, my lord. It's number 7, my lord. The opposite party number 2 and 4 are directed to consider the provincialization service of the petitioner. Act, he was terminated by the venture school SMC in the year 2003. The schools were provincialized under the 2011 Act and 17 Act. Now, my lord, considering all aspects as per existing rules and the interest of students within a period of 2 months, it's okay. Now see the counter in the main, this is the, my lord, preface of the order. Now see the main order, page 126, 125 and 126. Totally contrary, my lord. 125. 42. Got it. In view of the discussion observation made in the foregoing issues, the termination of the so-and-so was not as per law and appointed so-and-so in place of the petitioner. This is incorrect, my lord. I was not replaced by him.
Okay.
So far as, no, only one thing, only,
No.
only one line. So far, reinstatement of the petitioner is concerned as termination of service was illegal. So, termination of service. Now the question is whether the petitioner be provincialized or not, the authority will decide. This is the main judgment. But over in the preface, that 109 is saying within 2 months, and over here it is the concerned authority will decide as per law. Totally contrary, my lord.
Yes, he seems to be contrary. Otherwise, he was terminated by the school management. Now, whether now he can be provincialized or so this is some contradiction. So
Let the original record come.
yes,
Only, my lord, only I will pray, my lord, not for any stay or anything like that. Status quo as on date.
No, what purpose will be served by granting status? quo?
My over here, one remark is that I have replaced him. That is incorrect. I did not replace him. When I was in service, he was working.
and direction to provincialization also we could not comply with that lawsuit as for the new act lawsuit. Because he was terminated in the venture state lawsuit, but in 2003, now 22 years.
His approach came under 2011 Act, but in the meantime, 11 Act has gone on, now 2017 Act.
It takes some difficult lawsuits.
Heard Mr. Abedin, learned counsel for the petitioner, Mr. SMT Seste, learned standing counsel for the
Personal one.
Secondary Education Department. This petition under Article 226 of the Constitution of India, the petitioner has challenged the order dated 18/9/2025 passed by the learned Educational Tribunal Borneta in Education Case Number 04 of 2016. Peruse the petition and the documents placed on record, and also peruse the order dated 18/9/2025. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered folks with AD and also by usual process within a week from today. List the matter after 4 weeks. In the meantime, registrar shall call for the original record from the learned tribunal. The question of maintainability of the petition under Article 226 of the Constitution of India is kept open. Interim order of the petitioner will be considered after receiving the original record from the tribunal. List the matter after 4 weeks. Let the record come, we will see.
My lord, in the meantime, the status quo, my lord. It is a genuine prayer, my lord.
No, that's all right. Let the record come. We are not rejecting the request.
Status quo, my lord. Otherwise, there will.
Let the record come, we will see.
May I please, sir? May I please? Sir?
Yes.
The petition is before your lordship for non-payment of area salary of the petitioner, lordship. Petitioner was placed under suspension. He is an assistant teacher of Ghogapara, Niz Ghogapara LP School, lordship. Presently, that Niz Ghogapara Girls LP School affiliated with Haji Maskarali Laspur High School. Now serving as assistant teacher of Haji Maskarali Laspur High School. Petitioner was suspended in the year 5/1/2000 on 5/1/2008, placed under suspension. Lord. Thereafter, the suspension order was revoked. It's 14 lots. No disciplinary proceeding is initiated against the petitioner. Lord.
Heard, Mr.
Yeah, lord.
Learned counsel for the petitioner, Ms. Ann Pupan, learned standing counsel for the respondent in Elementary Education Department. The petitioner herein is aggrieved. Secondary, why?
I have no issue against the present. Yes, lordship, I may be allowed to plead. Secondly.
Why secondary education is a necessary part? Amalgamated.
At that time here, the school was not.
Okay. Equal line.
Oh,
The petitioner herein is aggrieved for non-payment of arrear salary for a sum of rupees 9,14,308. 308. Learned counsel for the petitioner submits that while the petitioner was serving as assistant teacher in Niz Ghograpara Girls LP School, he was placed under suspension by the order dated 5/1/2008. But no departmental proceeding was initiated against the petitioner, and thereafter the respondent number 4 revoked the suspension order of the petitioner by issuing the order dated 28/9/2013 with a direction that the petitioner shall be paid full pay and allowances during the period of suspension. Thereafter, the respondent number 5 had prepared statement of arrear salary year-wise in respect of the petitioner for the period from 5/1/2008 to 28/2/2013 for a sum of rupees 9,14,308. And after receiving the proposal of requirement of fund from the respondent number 5 for payment of arrear salary of rupees 9,14,308, the respondent number 3 had forwarded the said proposal along with connected documents to the respondent number 2 for taking appropriate action letter dated 23rd of October 2019. But till date, the petitioner has not been receiving the arrear salary, and being aggrieved, he approached this court by filing the present petition. At this instance, Ms. Anne Fukon, learned standing counsel for the respondent in elementary education department, submits that here the school of the petitioner was amalgamated with, what is the name of the school?
High school.
With Haji Maskandar Ali
Maskandar
Lahore
Ali.
High School by order dated 25/4/2022, and now serving as assistant teacher of the said school. And on such count, the director of secondary education is a necessary party in this process, and she applies for impleading the said director as respondent number 6. Respondent number 7. 7. Having heard the submission of learned counsel for both the parties, I have carefully gone to the petition and the arguments placed on record. Then it appears that there is substance in the submission of Ms. Fukon, learned counsel for the respondent in elementary education department. Let the director secondary education Assam be pleaded as respondent number 7 in this proceeding. The learned counsel for the petitioner shall file amended cause title within a period of 1 week from today. Let notice be issued to the respondents number 1, 2, 3, 4,
And
5. Treasury officer, Ms. Borua for Treasury officer. However, no formal notice is required to be issued since the respondent number 1, 2, 3, 4, 5, and 6 are represented by their respective standing counsel. However, extra requisite copy of the petition will be furnished to them during the course of the day. List the matter after 4 weeks. In the meantime, the respondent in elementary education department shall file their affidavit in opposition.
Public.
The petitioner was appointed as subject teacher in PM Sri Yudhishthir Saha School, Kachar in 1995. And since then she has been working there. As on today, Lordship, she is the most eligible senior most candidate to be considered for promotion to the principal. And that your Lordship will find at page 21. Page 21 is the seniority list. Number 4. But we can understand that they are above 57 years. And for consideration to the principal, one should not be above 57 years as per of the Assam Secondary Education Provincialized School Service Rule 2018. Now, my claim in this writ petition is for considered. I'm now 55 years of age and I'm the most eligible person. And if I cross 57, Lordship, somehow I'll become disentitled. Then, Lordship, another aspect I would like to point out, an order was issued at page 23, Lordship will see. Act as principal in charge by this order. Being the senior most person of the state school itself, I was allowed to act as principal in charge, but without any intimation. Next page, Lordship will see, page 26, at page 23 was kept in abeyance. notice without stating any reason. So neither to act as principal in charge and my main consideration for promotion to the post of principal and post
The
is
question
vacant.
is whether any step is initiated by the respondent authorities to fill up the post of principal.
No, Lordship. No.
Then
And the post is vacant. That when post is vacant and I am the senior most person, I have a right to be
No,
considered for promotion, Lordship.
they have not yet initiated the process.
Yes, Lordship will, there is a detailed procedure laid down. What is to be appoint regular principal Lordship, man, and this engagement is a pure temporary engagement.
Hmm.
It's a bit of undertaken when there is a vacancy and when there is a vacancy of principal. It's not to any person that it should be appointed the principal of that particular. Lordship, I understand that it is not a right for promotion, but my right is for consideration to the post of principal. Of these rules, Lordship.
No, you see, unless the process is initiated.
Yeah.
And unless they have rejected your claim or they have not considered your claim, where your right accrues.
Yes, my right accrues from Rule 12. It is their duty. It is their duty to assess the vacancy and initiate the process whenever there is a vacancy. It is their duty, and they do not perform their duty, your lordship can pass an order for mandamus. Because their inaction to perform the public duty, and it's an order for writ of mandamus. Rule 12, lordship will see. Not their discretion to keep the post vacant permanently. Now, if inspector of school is acting as the in charge principal, it is not process. There has to be a regular principal. Rule 12, lordship will see. Rule 12.1. 2046 page number. Rule 12. The post of principal in provincial as higher secondary schools should be filled up by direct recruitment from the candidate from the cadre of postgraduate teacher in senior secondary and higher secondary school and graduate teachers of higher secondary school as per procedure. Then lordship will see next para 3. Para 3 will see. The minimum qualification of appointment. Eligibility is provided under subclause 3. The minimum qualification of appointment to the post of principal in high secondary schools shall be as follows. Now, lordship will see subclause 5. Important, lordship. Before the end of each year, the inspector of schools, who is the member secretary of district selection committee constituted under Rule 6.2, shall make an assessment of the number of vacancies to be principal and to be filled in the next year within the district. So every year, inspector of schools has to make regarding number of vacancies.
So, Mr. Sisti, whether such exercise is carried out by the inspector of school?
Principal is concerned, I have no, but headmaster we have already initiated, but due to lot of cases are pending, doctor say given, so entire process has been stopped. So principal is concerned that I think right now it is not.
Okay.
Moreover, lordship, he was temporarily appointed anyway. I'm a regular teacher, lordship, subject teacher. My claim is for. Can be able to. For lordship, consideration for regular promotion to the post of principal. One person cannot be considered for a specific particular post. District-wide selection has to be made. Since 2021, the post is vacant, and Rule 12.5 says every year an assessment is to be made regarding vacancy.
Okay. Heard, Mr.
My lordship.
Learned counsel for the petitioner and Mr. S.M. Sisti, learned standing counsel for the respondent to Secondary Education Department. This petition under Article 26 of the Constitution of India, the petitioner has right for issuing direction to the respondent to give effect of the order dated. The petitioner has challenged the order dated 27/8/2025 and also to direct the respondent to give effect of the order dated 19/7/2025 and to allow the petitioner to act as the principal in charge of PM Sri Yudhishthir Saha, SS School, Behra, Bazar, Kasar. And also to direct the respondents to consider the petitioner for being promoted to the post of principal in any provincialized higher secondary school against available vacancy. The learned counsel for the petitioner submits that the petitioner is the most eligible teacher for being appointed to the post of principal, and that the post of principal of Sri Yudhishthir Saha SS School, Behra is lying vacant since the year 2021.
Yes.
2021. And that the respondent authorities have not taken any initiative to fill up the said post as per provision of the Rule 12. Rule 12 of the
Assam Secondary Education Provincialized School Service Rule 2018.
2018. And that the petitioner was allowed to hold the post of in-service by order dated 19/7/2025. But subsequently,
Next.
by order dated 27/8/20, by impugn order dated 27/8/2025, the said order has been kept in abeyance until further order. Under such circumstances, the learned counsel for the petitioner has tried for issuing direction. Now, prayed for setting aside the impugn order dated 27/8/2025 and also to issue direction to the respondent authorities to appoint the petitioner as principal in any higher secondary school. The submission of learned counsel for the petitioner needs further consideration. At this stage, a notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued since Mr. Sisti entered appearance and received notice for all the respondents. However, extra requisite copy of the petition will be furnished to Mr. Sisti during the course of the day. List the matter after 4 weeks. In the meantime, Mr. Sisti shall file affidavit in opposition, making the stand of the department clear in this writ petition. List the matter after 4 weeks. You can take back the rules.
Lordship.
Please, attends to non-payment of family petition put unmarried dependent daughter. And purpose of the notification and accordingly submit proposal wrong, my lord.
No,
Please,
Mr.
my lord,
Patgiri, the Director Elementary Education has already submitted the proposal to the Director of Pension.
Pension. Now pending, my
Yes,
lord.
anybody? Director of Pension? So what is the status of the proposal submitted by the Director dated 19/8/2025? Obtain instruction. Okay. We'll list in the next week. You obtain instruction. Heard Mr. Patgiri, learned counsel for the petitioner. The petitioner herein is aggrieved for non-payment of
Pension.
non-payment of family pension. Family pension. Mr. Patgiri, learned counsel for the petitioner, submits that the father of the petitioner, who was serving as Chokidar of Holongpara MV School, and he superannuated from the service on 31/12/1996. Thereafter, he had received a superannuation pension by PPU number 27966. But he suffered demise on 16/1/2002. Thereafter, the mother of the petitioner has received the family pension, but she also suffered demise on 3/7/2008. Thereafter, the petitioner became helpless as she was dependent on her parents, and she is also physically handicapped and unmarried dependent daughter. And in view of the Rule 143 of the Assam Service Pension Rule 1969, and in view of the notification dated 3/8/2017 and 9/8/2018, disabled son and daughter, unmarried dependent daughter of the deceased government servant is entitled to a monthly family pension. And in view of the aforementioned provision, the petitioner has submitted her pension proposal papers to the respondent number 7, who has forwarded the same to the respondent number 5 by letter dated 18/7/2024. And the same was again resubmitted on 19/8/2025 to take necessary action for sanctioning of monthly family pension. But the same is pending with the respondent number 5 till date. In view of the aforementioned position, it is provided that Ms. Fukon, Learned Standing Counsel for the respondent number 5, shall obtain the up-to-date status of the letter proposal dated 19/8/2025 and apprise this court on next date. List the matter on Monday, next Monday. 16. Okay. 17, okay.
I don't know why it is only. The matter relates to non-payment of pension. Is appearing lordship may issue notice, let it be listed on the bench sheet on the next date. Since there is no other fast food, it will be taken. I don't know why it has come. It is for the registry to see why it has come here.
Of which department?
This is the
Home department. Okay.
So ask how it has come to this court. Understand?
Yes. Heard Mr. Mannan, Learned Counsel for the petitioner, and Mr. G. Pegu, Learned Additional Senior Government Advocate. It is submitted at the bar that this matter pertains to bench stay, and accordingly it is provided that the registrar lays the matter before appropriate bench.
Day after tomorrow, because motion.
Okay. Should we fix a date? Or as soon as practicable?
Yes.
As soon as practicable by the registry.
Bless.
None appears for the petitioner on call, lays the matter after a week. None appears for the petitioner on call, lays the matter after a week.
Your lordship.
Yes.
Lordship. Happy.
Yes.
We are expected to file an I tracking the fair portion of the read petition. As per the
Fair person.
last week. Number 8/2025. Uh, and
Yes.
you can link it on Friday along with the I.
Friday.
Right.
Okay. Who will appear? P. Verdun. Your good name? Ms. So-and-so, learned counsel appearing on behalf of Mr. P. Verdas, learned counsel for the petitioner, submits that this matter may be listed on Friday along with WPC number 662 of 2025. PR allowed, recessal list the matter on Friday.
12 December. 39.
I pray for G order my to correct salary.
Okay. Hard Mrs. K. Devi, learned counsel for the petitioner, Mr. U. Sharma, learned standing counsel for the respondent in secondary education department. Mr. Sharma submits that though by order dated 1/12/2025, he was directed to obtain instruction. Yet the said instruction has not yet been received, and he prays for listening the matter in the next week.
Yes.
Nobody is less than
We have
1 hour,
getting
less than 1 hour journey from here. Why 10 days?
15 minutes Monday.
Next Monday? Okay. Mr. Sharma on Monday. Next Monday.
Wait a minute. 15 Monday.
Yes. Pardon?
Bit of compassion family pension, your worship. The detailed report by the Assam Agriculture University to the deputy to the government of Assam Agriculture Department. Page 69. Got it?
Yes.
May I read?
Is it necessary to read this letter?
No, basically what has happened is that joint service in the year 2016. He passed away in the year 2020. Meanwhile, what has happened in the year 2008? Students of KPK who are agriculture university what do you want the pay scale? What do you want the absorb pay scale? Actually, Indian Council for Agriculture Research. If the petition for a lordship agriculture university pay scale, he was continued from his appointment date, your lordship. Thereafter, what has happened? He was ultimately in the year 2003. Meanwhile, he passed away your lordship. They are saying that there's a deficiency of one part of service in the petition. Husband, your lordship. The output is that what in the year 2006, so lordship, lordship.
Okay, who is appearing for Agriculture University? You. Okay. Heard, Mr. Learned counsel for the petitioner and Mr. R. Gogoi, learned counsel for the respondent. 2, 3, 4, and 5. Who is appearing for 1? Agriculture Department. Commissioner and Secretary, Agriculture Department. Mr. SMT Sisti, learned standing counsel for the respondent number 1. In this petition under Article 226 of the Constitution of India, the petitioner has directed, the petitioner has prayed for, the petitioner has challenged the letter dated AAUC struck pen PEN dash 3059 struck 2022-23 struck CM struck 37 dated 25/1/2024 issued by the Comptroller of Assam Agricultural University, wherein it is stated that 1 month deficiency in the service of the petitioner's late husband to make him eligible for getting compassionate family pension, and also to issue direction to the respondent authorities to grant the benefit of compassionate family pension to the petitioner and other pensionary benefits. The learned counsel for the petitioner submits that the petitioner was husband of the petitioner was appointed as mechanic, driver cum mechanic in the year 23/11/2016. He suffered demise on
21/10/2021.
21/10/21. And that after his demise, the present petitioner has filed an application for granting family pension, compassionate family pension, but the same has been denied on account of deficiency of service for 1 month.
Yes, Lordship.
1 month.
Yes.
The grievance of the petitioner is that while her husband joined in the year 2016, the said period of service has not been taken into account by the respondent authority and arbitrarily denied the compassionate family pension to her on account of deficiency of service for 1 month. And under such circumstances, it is contended to allow this petition. The submission of Mr. Khatuniar needs further consideration at this stage. Notice be issued to the respondent, returnable in 4 weeks. However, no formal notice is required to be issued since all the respondents are represented by their standing counsels. However, extra requisite copy of the petition be furnished to them during the course of the day. List the matter after 4 weeks. In the meantime, all the respondents shall file their affidavit in opposition. Okay. It is further provided that Regis shall list the name of standing counsel of the Agriculture Department in the cause list.
41.
Legal Lordship, the petitioner postgraduate scholarship has been working and age assistant. As elected enrollment request for the year 2016. I take enrollment request and I have elected. Thereafter, level student position recommended my name. Thereafter, the state level committee did not recommend my name on the ground that they have obtained the report from Board of Secondary Education SEPA, Extended Education Lordship. SEPA has nothing to do with higher secondary education Lordship. On that basis, Lordship, my name.
How SEBA has furnished the report?
Lordship, it is.
If
there,
they are not the
I'll
authority?
show. I show Lordship, I'll show. Thereafter, Lordship subsequently, Lordship kindly pays 41 Lordship. This is the point of examination. Education Council reported that enrollment was 11 Lordship, page 41 and exam 4 Lordship. Lordship, 2016, history is my subject Lordship. Enrollment, Lordship, out of 7 postgraduate teachers, 5 postgraduate teachers reported that by order dated 30/11/2021, Lordship will get paid 44 Lordship. Lordship make Peru second. Page 49. It is adapted by level is Lordship. Lordship will get for provincialization. Second last Lordship. His service is eligible for provincialization. 49 serial number. The state level committee Lordship requested the director forces the matter Lordship. Thereafter, Lordship, the Director of Secondary Education issued letter to the board. Letter dated 12/7/2023 Lordship. For three, four posts. For creation of 3 to 4 posts. Lordship got a page 53.
Yes.
Subject, submission of proposal for creation of 54 number of posts for provincialization service of PC staff secondary education. If the Lordship it for serial number 5 Lordship. Left out post of higher secondary school number of posts. 7. I want that 7 Lordship. I want it to be paid for 3 Lordship. And thereafter, the matter was before the joint committee at page 59. Government accordingly placed the proposal before the joint committee. Now the joint committee to give proposal committee. That also done Lordship. District is 63 Lordship. Bottom. The incumbent is service joined it on 20 for document for service report and public authentic. All the educational testimonials are also verified and found correct. The fulfillment of enrollment in 2014, 15, and 16 as per Act, the incumbent holds first post. There, the state level committee recommended the name of this 54 person Lordship. Page 78 may kindly be given. And 58. May
Yes.
to the subject cited above, I have the honor to state that by the state level disciplinary committee. So our time has already recommended. Now the joint committee in its meeting on second paragraph 11/10/2023 appointed for further proposed application of the it shall be requested at the field level by its initially the committee called for district disciplinary committee chairman, now independent authority. That has also been done. Lordship kindly pay rules. My period 40 48 at page 81. I have put for that portion. Serial number 48, Lordship. So there, on the basis of the report of the independent Lordship, the Director Secondary Education prepared a report. Report page 84 relevant of. Serial number is 48. Not GT. Last one. Until the assessment report was as six for the year 2016, letter as per report obtained from Education Council and the year 2016 ought to be 12 and may be considered for potential. So the district committee recommended him and their lordship will kindly present any question by the joint committee. Lordship will pay 89 lordship. Resolution number. Lordship. The committee discussed the matter concerning the provincialization of service of Ranjan Regun, PGT Economics, Utpal Nath, PGT History at Rangasai Tea and Higher Secondary School, and also Nandeshwar PGT Board Bill, verbally ACS School report. The services of Ranjan Regun, Utpal Nath, and Nandeshwar are not provincialized earlier due to non-fulfillment of requirements and of students in their respective subjects. And next lordship is important. On the basis of fresh report regarding enrollment received from SSEB lordship, division 2, the state level scrutiny committee recommended that so and so. Now the impune lordship, but the joint committee decided to verify the proper reason as to how the enrollment data can be changed. Now I am active by the lordship. Lordship. State level committee under section 30 lordship is the highest authority. After district school committee recommended someone's lordship, it comes to state level committee. When the state level committee recommends lordship, joint committee doesn't have any business lordship. And that joint committee is a body lordship. I have passed by this honorable court lordship. Lordship is for a moment. Page 19, lordship. That the case the petitioner was recommended by the expert committee and thereafter for provincialization of service. Since such recommendation are made, or evidently on account of the opinion letter by the committee for committee. Each court has requested the authority to place before this court material to the meeting of a joint committee for admitting proposal of service of teacher of so and so. After the set is scrutinized and recommended by the jurisdictional district level committee and state level committee. As query was also raised on account of the provision of the Act 2017 do not envisage of committee for joint committee for prohibition of particulars for service teacher and so for their service. Paragraph 10 below lordship. This code secretary to the government of Assam, Department of School Education, report of a communication dated so and so. It was contended that the state committee was constituted personnel from various departments. It would department was that would have proposal as made with regard to this teacher of so and so. Now, this in view of the provision of the Act 2017, hope that this committee is not a committee in which the Act of 2017. Now, place the matter joint committee again in respect of the petition and subsequently to the now, once Better before the committee. And now, consider one. My name was recommended to the
So that's all right, but are you challenging the
Lordship, I have
constitution of
challenged.
joint committee in this
Lordship, I
petition?
have. And
What is your pair in?
prayer, Lordship.
Ah.
Page 29, Lordship. Set aside for the joint committee constituted verification of particular fixers so. Set aside for the designation number A of the joint committee calendar 25 and 25 who are the petitioner. Lordship, joint committee initially directed the district school committee to verify. Now, committee on the basis recommended. The committee said it should be verified by the authorities. Now, decision may Lordship. The joint district committee is a committee. Now, subsequently, the joint committee decided to verify the same to the CFP committee. That is district commissioner. Thereafter, the independent committee, they have directed the district commissioner to verify. And most of the cases are verified by the subordinate lordship. Lordship, it is what is the committee, now district committee. Lordship. And all these things, a report was prepared for lordship. That the
Okay,
level committee
let-
recommended my name, lordship.
Let him obtain instruction.
So may I put it, okay, both the cases, they can be instead of letting them take it up. I have to take the details for.
No, the other matter has been fixed on Wednesday. Let it be on Wednesday. Heard, Mr. Islam Learned Council for the petitioner, Mr. S.M. Tesesri, Learned Standing Council for the respondent, Secondary Education Department. The petitioner herein is aggrieved by the impugned resolution of the impugned resolution number 8 of the Joint Committee, dated 25/9/2025, 2025, by which the respondent, no, by which the Joint Committee has decided to verify the proper reason as to how the enrollment data can be changed. Mr. Islam Learned Council for the petitioner submits that the name of the petitioner was recommended by the district scrutiny committee twice, and by the state level committee thrice. And despite such recommendation being made by the two statutory committees, the service of petitioner has not been provincialized, and instead the same was placed before a committee which is not envisaged under the Act of 2017. And under such circumstances, Mr. Islam has consented to set aside the impugned resolution of the resolution number 8 of the minutes of the meeting of the Joint Committee dated 25/9/2025. Where is the petition and the documents placed on record? List the matter on Wednesday. In the meantime, Mr. Sisti, Learned Standing Council for the respondent in Secondary Education Department shall obtain instruction as to under which provision of law the Joint Committee has been constituted by the state respondent. List the matter on Wednesday along with WPC number. What was the number? Okay. Wednesday. Okay.
Sorry, next week, lordship.
Take a date from him.
14 of
registered organization, Your Lordship. They are all, they represents the qualified teachers who are appointed on contractual basis by the SSA, Your Lordship. And in fact, Your Lordship, there has been a long-standing demand from their side, Your Lordship. Initially, although they were contractual, Your Lordship, for getting basic, that has been granted to the teachers, Your Lordship. Accordingly, Your Lordship, government has taken policy decision, Your Lordship.
So what is the impugn order?
Your Lordship, what
page
has
number?
happened? Your Lordship would kindly come to page 33, Your Lordship. By which you are aggrieved by this, Your Lordship. They have given us the DA, Your Lordship. In persons, the government notification number so and so, contractual teachers and others so and so, Assam having been drawing 17% their allowance. Meanwhile, got to Assam Finance Department further enhanced 7% DA, 11% with effect from so and so. 3% with effect from 7/2001, 21 by office memorandum 6/12/2021. 3% with effect from as the government following the beneficiary consequential teachers and staff and officers under SSA Assam, Your Lordship. Now what has happened here, Your Lordship? Kindly come to page 25, Your Lordship.
Yes.
Here you show this is a letter by the Commissioner and Secretary to the Government of Assam. Lordship. Here it says, Your Lordship, in fact, directed to state that beginning it was the contractual PUP teachers under SSA will get the same benefit of teacher under the Director of Elementary Education Assam. Based on that, Your Lordship, they have decided to give us benefit under Your Lordship 7th pay commission.
So the DA awarded to you by this impugn order is less than the 7 pay commission.
Your Lordship, the regular teacher, the granted to regular teachers are more than what we have been giving, Your Lordship.
So where is the cert to show that regular teachers are drawing more than you?
That is reflected from this order itself, Your Lordship. Kindly come to page 33. This is for us, Your Lordship. Would kindly see. They have mentioned here, Your Lordship. Notification number so the contractual teacher, staff, officers under SSA Assam having been 17% DA allowance from so and so. Meanwhile, this part is important, Your Lordship. The Government Finance Department further enhanced 17% DA. With effect from 21, 3% with effect from 1,021, and 3% with effect from 1/1/2022. But Your Lordship, whereas that was Your Lordship, effect that Your Lordship will find that so far as we are concerned, as such, government in Elementary Education Department is pleased to allow following DA benefit for the contractual teachers and other staff of the Assam, 10 enhancement of DA with effect from December 2022. From Your Lordship, 2021, as has been granted to others, balance with effect from 2023. 7 by Your Lordship, not from the day on which Your Lordship, the other employees of the state government, Your Lordship, is getting including the regular teacher.
So this okay, 11% with effect from 1/7/2021. 21.
one, Your Lordship. That they have not given, Your Lordship.
The remaining 7%?
7%, Your Lordship.
No, 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 sorry, 6%?
That Your Lordship would find, Your Lordship, they have given us 10%, Your Lordship.
Okay.
Now, our case is on very simple thing. Once you have decided to give, and Your Lordship will kindly see the word used, Your Lordship, in page 25 is the benefit, Your Lordship. Very that I am directed to state that from beginning it was decided the contractual LP teachers, they will give the same benefit of regular teachers, Your Lordship. Now, once you say by taking a policy decision that the contractual teacher will get the same benefit, then Your Lordship, DA is also included in that benefit, and we must get it from that, Your Lordship. That was our case, Your Lordship. And in fact, Your Lordship, why they have, Your Lordship, done this, Your Lordship, one, the task we have been asked to perform, Your Lordship. Your Lordship, kindly take up page 27, Your Lordship. Then, Your Lordship, we are given the other benefits also, Your Lordship, by this 2020 letter, Your Lordship. July 2020, first paragraph.
No, but we are only concerned with the DA.
DA, Your Lordship, not rest. But what I am trying to show to Your Lordship, we are, Your Lordship, is Arda's task, Your Lordship, so far as we are concerned, Your Lordship, they admitted that with a view to maintain pupil teacher ratio, especially in the schools, remote and isolated areas. We are remote and isolated time, Your Lordship.
Okay.
Even then, Your Lordship, we have to be deprived of that. Now,
what is the extent of the government?
Lordship, I will show that, Your Lordship. Initially, Your Lordship, when you took up the matter, Your Lordship, they say that it is an active contract of the government.
On which date?
Your Lordship will kindly come to my reply, Your Lordship. On several occasions, Your Lordship. We have annexed all the orders, page 40 onwards, Your Lordship. Page 50, Your Lordship, will find. This is the first.
It is the affidavit.
My affidavit in reply, Your Lordship.
Paragraph number?
Your Lordship, 50, these are the orders, Your Lordship.
There is a mismatch. Okay. Yes, Mr. Khatoniar?
So they find their difficult, Lordship. After Lordship, I annex these orders. So clearly they said that it is under active consideration, and suddenly, when Your Lordship needs to status, Your Lordship, finally they filed a affidavit. They said, Your Lordship, their affidavit, Your Lordship, is dated 7/11/2025, para 5.
7/11/25.
Page number 36, Your Lordship. Running page 36. May I read, Your Lordship? While categorically denying the claim of the petitioner for extending the benefit of enhanced DNS allowance with effect from the date of grant of such benefit to the regular CONF employee, this is most respectfully submitted that the said claim is wholly misconceived, untenable, devoid of legal foundation. The petitioners, being contractual employees engaged under a specific scheme in parity with regular government employee whose services conditions are governed by state rules. The entitlement of the petitioners to DA and other allowances is strictly regulated by the terms of their contractual engagement and by specific orders or notification issued by the competent administrative department from time to time. Hence, the petitioner has no vested right or enforceable claim to seek DA benefits from rates applicable to regular employees of the state government, Your Lordship. This is basically, Your Lordship.
Now, your lordship, this stand is itself is not tenable in view of the fact that it is their own decision, your lordship, that we should be paid, your lordship, similar benefit as to the that of the other disadvantaged, your lordship. Once you take a decision, you cannot now resile from that decision and come up with a plea that since we are contractual, we cannot claim it, your lordship. That argument itself cannot stand in view of what they have taken, but their policy decision, your lordship.
Mr. Khatuniar, you see page number 25, the letter of the Commissioner and Secretary to the Government of Assam, addressed to the Mission Director SSA.
Yes.
So it is clearly stated that it was decided that the contractual LP UP teachers under SSA will get same benefit of regular teacher under the Directorate of Elementary Education Assam.
Yes.
Then why this stand up by government?
7 pay commission benefit was granted to them
Mm.
from a subsequent date from 1/4/2017.
Mm.
And thereafter, my lord, again a decision was taken to give the additional benefit of PA. That my lord will find
Yes, Mr. Borthakur has already shown that letter.
one more notification is there, my lord.
Uh,
Passed by cabinet decision, my lord. Page 30. In presence of the cabinet decision in the meeting held on 1/1/2022, the government of Assam is pleased to enhance 5% tenure allowance for contract officials and other staff officers of the SSA with effect from 1/1/2022. So it was the cabinet decision to give effect from 1/1/2022 in respect of BA value.
mm.
And my lord, kindly come to the notification.
Mm.
The notification by the finance department, page
Mm.
28, and my lord, subsequent notification at page 31. It clearly mentioned that in the subject line, payment of DNS allowances, DNS relief to the serving government employees, state government pensioners, family pension holders, extraordinary pension holders in revised rate with effect from so and so. These notifications are specifically meant for the regular developer. So benefit of these notifications subsequently granted to the contractual employees. Percentage of cabinet decision from a particular date.
Mm.
Since they are contractual, madam, their terms and conditions are governed by their agreement with them, madam.
Mm.
They cannot leave the parity with the regular state government employee. It is not the case that we are not giving the benefit.
No, that's
They have
right,
been given
but,
the benefit.
once it has been decided according to this letter
Yes.
dated 28th of July 2017 to grant the same benefit to the contractual teachers. Why the government has?
With regard to my lord, 7 pay commission.
Mm.
And these subsequent notifications are with regard to the my lord, DNS allowance. With regard to 7 pay commission, that benefit was given.
Mm.
Decision was taken to give the same benefit as that of the regular employee as per 7 pay commission. That was
7 pay
granted.
commission also specified the percentage of DA.
If my lord will find the impugn notification,
Mm.
it is from with respect to 2022, my lord.
Mm.
Provision that is 119/1/2022. The contractual teachers under SSA have been drawing 70% allowance DA with effect from 2022. Meanwhile, finance department is in 2021 they have enhanced, my lord.
Mm.
Subsequently, 11%, then 3%, then 3%. So that enhancement was in respect of the contractual employee was given from with effect from 2022.
Mm.
In respect of regular employee, it was with effect from 9/21. Respect of contractual employee has been given effect from 2022.
Why a different date?
Because they are from contractual employee. Because this instruction OM was issued by the finance department
Mm.
and for the regular employee. And administrative department, in fact, we have because this was under consideration in 2021. And
No, while they are discharging the same duties, can you make any classification on this point?
otherwise, they are.
Decision of EP REPA.
If
Is
we
it available with you, Mr.
we
Borthakur?
are not denying that they are not
The decision of Supreme Court in EP Royappa. EP Royappa.
But they are not performing the similar duties. But their entry to the service is different, my lord.
No, maybe, but can it be a ground for classification?
It's not because since their terms and conditions are governed by the contract. So they're giving them the same benefit but from a subsequent date, my lord. And there's other development also, my lord. Subsequently, the government of Assam has initiated a special recruitment drive. And from special recruitment drive, some of the members of the petitioners association have already been regularized as regular employment.
All right.
And they have been granted us all benefit. And
But why should they will not claim their past services, benefit of their past services rendered by them?
in the
Why
special
should
recruitment
they
drive,
forfeit
there is
it?
a specific clause that they will get the pay benefit from the date of initial pay scale, from the date of joining.
Okay.
Initial pay, and they have accepted that condition. In fact,
No,
we
they
have
are-
made an
maybe-
amendment to the
maybe.
rules. We have made an amendment to the rules, Mother, and person that special recruitment drive was initiated, they have accepted it, Mother.
Maybe, but that is also has to be tested on the ground that they are in a weaker position.
No, Mother,
So
but
bargain with
they have
the,
not- they have not challenged it, Mother. Whoever accepted the condition was not challenged it.
So far as your lordship, one section of the TET teachers, your lordship, they have your lordship opted for your lordship regularization as a new fresh recruitment, your lordship, but rest are still there, your lordship, whom I am representing, the rest. Not all, your lordship.
no,
Petition letter is not clear, my lord.
Mr. Borthakur, you say now the issue before this court is
Lordship.
whether a classification can
Can
be
be, your
made
lordship.
on the basis of this contextual
Lordship.
and regular,
Lordship.
two different dates.
Lordship.
You come prepared on, we will
Lords.
fix it
Lordship.
on Thursday?
Yes, Lord.
Lordship.
Immediately after vacation.
No,
Thursday, your lordship.
Thursday, Lord.
it's small
Thursday.
matter.
Over there.
Photo day.
The test is whether it is a
Oh, yes, my lord.
classification is
17 is-
reasonable or not.
17 is
17. Okay. Heard Mr. Borthakur, learned counsel for the petitioner. Mr. Khatuniar, learned standing counsel for the respondent in elementary education department. And Mr. Bora for SSA. SSA. And Bora for finance department. Heard in part, list the matter on Thursday,
18th, my lord. 18th.
18th. Okay, 18th.
Thursday.
Thursday.
Of the lodge.
Deeply of them.
Met is your lordship. My lord, here in this case, lordship, what happened, lordship? Petitioner was lordship initially appointed in one ME school lordship, namely Avidraja ME school lordship as a graduate teacher lordship. And subsequently, he was promoted to the post of headmaster of the Avidraja ME school lordship. In the year 2013 lordship, wherein lordship, the respondent number 4 lordship, he was serving in a venture school, which is named as lordship Shadin Bazar High School. And in the year 2013 lordship, with effect from 1/1/2013, their school was provincialized lordship. And since 1/1/2013, he lordship has been serving in the graduate scale of pay lordship. Subsequently, lordship, in the year 2017 lordship, the Avidraja ME school, the petitioner's earlier school, and the Shadin Bazar ME school, both schools were amalgamated along with another LP school lordship. So now the Shadin Bazar High School is an amalgamated high school lordship. fact is that, Lordship, now the respondent number 4, Lordship, who degree, that was in the year 2015. School was provincialized with effect from 1/1/2013. So I have obtained, Lordship, certain information that without any Lordship permission from the authorities, he obtained his B.Ed degree. On ground, Lordship. Subsequently, in the year 2017, Lordship, the school was, Lordship, amalgamated. So now the school become an amalgamated high school, Lordship. So the rules prevalent, Lordship, that should be as a amalgamated high school. So when the amalgamation order passed, Lordship, here, your Lordship may kindly see the amalgamation order, page 33, Lordship. Yeah, the Sadinbajar High School, Lordship, headed by headmaster, earlier headmaster Jainal Abdin Loskar. And next page, Lordship, the Abid Raja ME School, headmaster is the present petitioner, Lordship. Schools were amalgamated, and as per rule 14, Lordship, 15, Lordship, the petitioner become the assistant headmaster of the school, Lordship. So now, Lordship, after the death of the Lordship, the earlier headmaster of the Sadinbajar High School, which is an amalgamated high school, Lordship, the petitioner was, Lordship, by order dated 26/2/2021, Lordship, the petitioner was allowed to hold the charge of the headmaster of the school, Lordship, in charge headmaster of the school, Lordship. And the present respondent number 4, Lordship, he challenged the said order before dishonorable court, Lordship. Dishonorable court, after considering the facts, Lordship, that by order dated, Lordship, 12/10/2023, Lordship, passed an order saying that a fresh decision shall be taken by the director after hearing all the parties, Lordship. But in that case, Lordship, that regarding amalgamated high school, that rule was regarding that rules, Lordship, that was never been, Lordship, taken into consideration while passing the said order, Lordship.
But whether you have raised any such issue before the court?
No, Lordship, Lordship, because rule is there, Lordship, it is an law is
My
there.
question is whether you have raised such an issue before this court at the time of passing the order?
No, that writ petition was filed by the present.
Subsequently, can you again raise the issue
My lord,
in a separate writ petition?
no, my lord, because that writ petition was filed by the present respondent number 4, Lordship, and I am merely a respondent there in that writ petition.
Maybe.
So, Lordship, now your Lordship may kindly see, Lordship, then, Lordship, the impinned order passed, Lordship, by the director.
Page number?
Lordship, impinned order is at page, Lordship, 52, Lordship.
52.
Here also, Lordship, the director, while passing this or impinned order, Lordship, did not consider the Lordship rules, Lordship. I take your Lordship to the rules, Lordship. What rules says, Lordship, about the amalgamated high school, Lordship. My lord, if Lordship may kindly peruse first Rule 15, Lordship, Rule 15 of the Assam Secondary Education Provisional Service Rules 2018, Lordship.
Rule 15.
Rule 15, Lordship, is regarding recruitment to the post of assistant headmaster. What is the requirement, Lordship? The petitioner being the assistant headmaster of the high school, Lordship, what it says, Lordship, Rule 15, Sub-Rule 2.
Yes.
Eligibility for the post of assistant headmaster, assistant superintendent, as the case may be, shall be as follows. A, he must be BA, BSc, BCom from any recognized universities. B.Ed is not a mandatory, Lordship. B, he must have at least 10 years of teaching experience as a graduate teacher. Amalgamated high school, the headmaster of the ME, MB school is eligible for selection as assistant headmaster, subject to the condition that the incumbent should have at least 5 years experience of headmaster in the ME school if he is a founder headmaster, and 10 years of experience as headmaster in ME school and founder headmaster. So this is the rule for appointment of assistant headmaster, Lordship. So the petitioner was at the time of amalgamation, Lordship, the petitioner was adjusted as an assistant headmaster, Lordship. Now, Lordship, the Rule 14, Lordship, which is regarding recruitment to the post of headmaster, Lordship. Rule 14(2), Sub-Rule 2, Lordship.
You are referring to which book? This one?
Actually, I have, Lordship, did not found this book, Lordship, in the vendor, Lordship. So I have taken the rule, the online copy. I have
35. Yes.
So rule 14, Lordship,
Mm.
sub-rule 2. Eligibility for the post of headmaster. High school, high madrasa, as the case may be. A. He must be a BSc BCom with BT BEd degree from any recognized university in respect of Hindi teacher having so and so so and so. Shall be considered instead of BT BEd. B. He must have at least 10 years of teaching experience as graduate teacher. So this is the Lordship rule regarding recruitment to the post of headmaster in a high school. Subsequently, Lordship, provided that the graduate teacher shall include the cadre of assistant headmaster for the purpose of selection to the post of headmaster, and the seniority of the assistant headmaster shall be counted from the date of joining as graduate teacher with graduate scale of pay. Further that, in case of amalgamated high school, where ME MV schools has been amalgamated, the assistant headmaster is eligible for selection as headmaster, subject to the condition that the incumbent should have at least 15 years of teaching experience as graduate teacher, including the period of service in the erstwhile ME MV school. So, Lordship, here in this case, Lordship, for the post of assistant headmaster, because the legislature very much, Lordship, aware that, because earlier I show your Lordship regarding appointment, recruitment to the post of assistant headmaster, wherein BT BEd is not a mandatory qualification, Lordship. And here in this Lordship rule, the rule given a specific proviso so that all the headmasters who were earlier appointed or serving in the Lordship post of headmaster in the ME school, Lordship, they may benefit, Lordship, from this proviso of the rules, Lordship. So here in this case, what has happened, Lordship? For a fresh graduate teacher who is the high school, Lordship, he must have 10 years experience as a graduate teacher as per sub-rule 2 of rule 14, Lordship. 10 years experience along with BT BEd and BA BSc, Lordship. But for the Lordship persons who were in the post of assistant headmaster, and admittedly the present high school is an amalgamated high school, Lordship. So for the post, for those teachers, Lordship, the legislature very much awareing about those facts, Lordship, so that the Lordship promotional avenue of those teachers shall not be, Lordship, halted, Lordship. So that rule was, Lordship, enacted by the legislature. So now my prayer is that, Lordship, I being served in the post of assistant headmaster of the amalgamated Sadin Bazar High School, Lordship, I am very much eligible for the post of headmaster of the school, Lordship. And on that count, Lordship, being the senior most graduate teacher, Lordship, I shall be hold the headmaster of the school. This is my submission.
Yes, Mr. Professor, what is your stand?
Lord, regard to the NOC issue, this court has already settled that the NOC is not a requirement to qualification. So, with regard to NOC, and regarding the my learned submission with regard to rule 14 and 15, my lord, rule 14 clearly mandates, my lord, one must have the BEd degree. Without BEd degree, one cannot even hold the charge of the master of the high school.
So the petitioner does not possess the BEd degree?
Yes, he is out of the zone.
Okay.
Yes, he is out of the zone for consideration. The last round also, my lord, during the last round of litigation, my lord, they have, this honorable court has already settled this issue between both the parties. And in the order itself, my lord, this honorable court has taken the Jagannath Pegu judgment, my lord, taken into consideration. This says, my lord, even for the in charge, one has to fulfill the required criteria as per the rule.
That decision is with you?
It's certificate there, my lord, 2007 3 KMP 389.
Yes.
Lord, the order put to challenge by this learned friend, my lord, is doesn't substantiate his argument, my lord. It interfered. He can hold the post of in charge, assistant advanced, board, master ex officio, amalgamation. It doesn't give him a right to, my lord, considered for the post of advanced in charge as well as for regular without having the paid degree. And 15 years of teaching experience, it is for those teachers whose services have been amalgamated with the high schools. And 10 years of teaching experience for the teachers who is initially born at high school. This is the difference.
Mr. Kaushik, what is your stand?
Rule 14 is very clear. Rule 14 has two conditions. One is the educational qualification and other is the experience. Now, there is a distinction between a graduate teacher of the high school and the assistant headmaster of the ME MB school who has been amalgamated in the graduate. For the graduate teachers of high school, they need 10 years of experience. However, my lord, the distinction is given in the provision. For the teacher, assistant headmaster who has been amalgamated in the high school would require 15 years of experience. But the reason is very simple, my lord, because when their appointment was made in the ME and MB school, they were in the intermediate scale. They acquired the graduate scale of pay only when they were appointed as the assistant headmaster in the MB, headmaster in the ME and MB school. Now, after amalgamation, therefore, they require 15 years of experience to become a headmaster. And the admittedly, the petitioner do not possess the educational qualification. That is VA. And as has been referred by my friend, in Jagannath Peku's Mother, this honorable court has said the qualification and the as it is laid down for the regular promotion would be applicable also for the in-charge. That's true.
Okay. Okay, we'll pause the order.
My lord, may I submit some?
Yes.
All those judgments, lordship, regarding a regular high school, lordship. But here in the instant case, lordship, this is an amalgamated high school, lordship. So the legislature, lordship, because, lordship, the amalgamated high school, that proviso was specifically inserted in the rules, lordship, to facilitate those teachers, lordship. Otherwise, lordship, the avenues of the teachers, lordship, the headmasters, lordship, who presently holding as an assistant headmaster, lordship, that will be halted, lordship. So the legislature is very much clear, because in the amalgamated high school, lordship, in the sub-rule proviso of the sub-rule 2B, lordship, no lordship or the lordship whisper about the BT B.Ed degree. And in the post of assistant headmaster, because the assistant headmaster rule 15, lordship, regarding recruitment to the post of assistant headmaster, the BT degree is not a mandatory qualification. So if one person is appointed as an assistant headmaster by virtue of amalgamation, lordship, then he is become the assistant headmaster of the school, lordship. So after coming into play of rule 4, proviso of the rule 14(2)(b), lordship, he obviously is eligible, lordship, for the post of headmaster, because this school is an amalgamated high school. So in earlier all the litigations, lordship, that points never raised, lordship, because this is a clear rule, lordship, to facilitate, because this is a beneficial, lordship, proviso given for the assistant headmasters, lordship. Otherwise, they will never get any promotion, lordship, only due to, lordship, that because earlier they are serving as a headmaster of the ME school, and after amalgamation, lordship, due to exigency of the government, lordship, they will stop, lordship, from further promotion, lordship. So keeping in mind that, the legislature very clearly, lordship, enacted. So your lordship may kindly consider that aspect also. I look.
We'll pass the order.
In this case, instruction was sought for from the BTAD, who is to pay that fixed pay amount, my lord. Regarding earlier order is, it's clear, my lord, earlier order of this court.
You have made a query, my lord, that is there any available in the state managing committee, my lord? But
No.
their judgment will not cover his case. My lord. That judgment will not cover because the appointment has been made by, their appointment hasn't been made by school managing committee. So their judgment would not cover, my lord.
That was government standard, my lord, regarding that managing committee's judgment they annex in their affidavit, my lord, because that was appointed by managing committee in the venture stage. And my lord, that another case was that they sought for regularization. Our case is totally different. We are contractual employee, my lord, we appointed in fixed pay until termination. And we have no prayer for regularization, only, my lord, that contractual amount that should be paid. And in that regard, lordship sought for instruction, who is to pay. That instruction.
Lordship, to reconstruct the file, my lord, so as to enable the updated instruction, my lord. So some time may be given to us, my lord, because the affidavit that was filed. Yes, it was signed by the earlier council, my lord, the affidavit. So, my lord, we need to take updated instructions, my lord.
No, direction was to obtain instruction
Lordship,
as to whether there is any fund available in the account of the school management committee.
Lordship, that is what, my lord, the WPC order did not cover his case, my lord. Because they have not been appointed by.
No, that will cover or not cover will be decided later on.
Lordship.
You have been asked to obtain instruction whether any fund is available or not.
That instruction BPC would not be able to, my lord, because school managing authority is completely a different body, my lord.
No, who constitute the school management committee? The government?
Government, my lord.
Then
BTC would be able to, as per my instruction over verbal instruction.
then we will pass similar order
Lordship,
like the WPC number 7878 of 2017.
that will not have, my lord.
That person were, my lord, appointed by the managing committee prior to provincialization. And our case is, my lord, is appointed by the inspector of the school. And the state is responsible, that's why, my lord.
No, who referred this? No.
Even if, my lord, the managing committee pay, we have no objection.
No, Mr. Lusami, who referred this decision 7878 of 2017?
That, my lord, the government in affidavit, my lord.
Okay.
Yes, my lord, but now we have come to know this judgment will not help, my lord. So, my lord.
But earlier it was referred by you.
Dear counsel, my lord, I have to take the instruction that is bringing for some time.
Okay, next week let her obtain updated instruction.
My lord.
Heard, Mr.
After vacation, my lord.
Hussain.
No, it's necessary, only instruction, my lord.
Immediately after vacation.
You said this is a repetition of 2020.
2020.
The vacation, my lord, because it will be difficult for us, my lord, for me.
Heard Mr. Goswami, learned counsel for the petitioner, Ms. Bora for the respondent BTC, Mr. Kosit for 1 and 3, Ms. Bora for respondent number 2. Ms. Bora submits that the required information has not yet been received by her, and she pressed for listing the matter immediately after reopening of the vacation so that she can obtain updated instruction. Where allowed, Rosicel is the matter in the first week of January. Fix it. 8th of January.
Kindly page the last order, man.
Who is for secondary education department? So you have been granted 3 weeks time to obtain instruction in respect of the missing service book. Received. Heard, Mr. Hawk, learned
Chief, here is your lordship.
counsel for the petitioner.
Here, it has mentioned that it is that as the pension book has been submitted by the office of the DEO, Kamrup Amingaon, so the communication has been done by letter so and so on dated 29/10/2025 for the original service return. It is prayed before your honorable court that the service book is about to reconstruct as early as possible. The lack of documents and relevant papers are being collected by the office to the undersigned to authenticate the special family pension in favor of the petitioner as per the lordship. So there is some documentation left, your lordship, for which they should short some time, your lordship. 3 weeks time may be granted, your lordship, to verify the authentication of the collective document.
Heard, Mr. Hawk, learned counsel for the petitioner. Ms. Das, learned standing counsel for the respondent in secondary education department. And Mr. Sorma for 1, 2, and 3. Mr.
I am
Pegu, you
appearing
are
for 7 and 8. Elementary education.
respondent number 4.
I'm for secondary education, 7 and 8. Director of secondary education and inspector of the school.
Corresponding number for INP.
5. 4. Respondent number 4.
Treasury Kunda.
Pursuant to the order dated 12/11/2025, Ms. Das has obtained written instruction dated 18th of December 2025, and on the basis of the said instructions, she submits that a pension book has been submitted by the office of the district elementary education officer, Kamrup Amingaon. And the communication has been done by letter number DEEO/K/A/MISC/part 2 2025 dated 29/10/2025 for the original service book. And the process for reconstruction is going on, and praise for granting some more time. Now, and the authorities are praying for granting some more time. There is a lot of recessal list the matter immediately after reopening of the vacation. In the meantime, Ms. Das shall obtain updated instruction and apprise this court on 31st January.
আগাই দেখো that means 3 months
21 January.
As per last order, my lord, the AG and the AG is to give the submit the instruction, my lord.
I have received the instruction. That, my lord, the grievance of the petitioner was with regard to non-receipt of the benefits under the ACP scheme. In the last occasion, the parent department, the council appearing for the parent department of the petitioner, my lord, placed document to show that the benefit under the ACP was granted to the petitioner. On going through the communication, he had raised certain demands that no benefit has been advanced to him, my lord. Because that document showed, my lord, as on 1/7/2010 and as on the date when the SEP was granted, the pay scale of pay remained the same. So on that, my lord, I was asked of the instruction, I have received my instruction, my lord. The instruction is, as per the provisions of the SEP scheme, specifically what has been stated in paragraph 17, I have provided that SEP scheme, my lord. The fifth man would be in the higher grade pay. They will not get the benefit of the higher pay scale, my lord. So if lordship sees the document, my lord, as on 1/7/2010, the scale of pay was 20,730. And
You are referring to which page?
the document for the last occasion he had provided the
This pay slip.
pay slip, my lord.
Yes.
As on 1/7/2010, she has got it, my lord.
Third page.
First page one.
Yes.
As on 1/7/2010, the pay scale is 20,730. And the grade pay is 4,500. She has seen that, my lord. Now, if lordship turns to the next page, my lord, as on the date when the ACP was granted, the benefit of ACP, that is 1/1/2011. That the pay scale is same, my lord, 20,730. But the grade pay is different, my lord, 4,600. So that is the benefit which has been given, and that is the only benefit which he is entitled to. And
As per the scheme.
now, provided the scheme, my lord, lordship comes to the scheme at paragraph 17.
Yes.
Lordship has got that, my lord.
Yes.
The ACP and envisages, that's how you got that paragraph, my lord. Third page, my lord. Third page of the document. Lordship has got that, my lord. The ACPS envisages placement in the immediate next higher grade payment within the existing payment of the employees. Now the payment won't change, my lord. Only the grade pay will change, and that is what we have granted. His grade pay was 45. Now it has been increased to 46 under the ACPS scheme. If I read out the entire paragraph now once again.
No, not necessary. Not
Envisages placement in the
Mr. Sharma, not necessary. So you obtain instruction?
Let them file this thing through an affidavit, my lord. Because
the benefit has been granted, my lord. If he has any grievance, he'll have to file a new writ petition. This writ petition won't suffice. Because an order has been passed, and my lord, the same issue was raised before another writ petition by the same petitioner. He filed a contempt application. That contempt application got dismissed, my lord. I've got the instruction. What remains after this? Same issue was raised in another petition. This petition number is given there of them again. Contempt application was filed, contempt was dismissed. May read the instructions on the first page. Will reveal everything.
clause 11, 19, 20.
Okay.
The scheme clause 19. 18 and 19.
No, Mr. Pukesh, so if you have preferred another writ petition seeking the same relief, if the same was dismissed, how can you file a subsequent writ?
No, this is not dismissed, my lord. The order of this honorable court is there.
Where?
It's next to page 26, my lord. Not dismissed. Thereafter, contempt is filed, my lord. To closed.
And in the contempt, everything is recorded. Last of the.
Other benefits are there, my lord. All the some portions have been given. Therefore, it's to closed, my lord. But let me read.
Was in the paper.
My lord, clause 18 of the scheme, SCPS scheme, my lord. 1819, my lord, sorry.
Goes in my favor, my lordship.
Just let me read get it clarified.
Clause
19. Benefit of pay fixation in the form of one increment at the rate of 3% of basic pay available at the time of regular promotion shall not be allowed at the time of financial upgradation under SCPS. The fixation shall be, however, be given at the time of regular promotion, even if it is in the same grade pay as SCPS. In case where the feeder and promotional posts are in the same grade pay and the incumbent of such feeder post is promoted to higher post after the grant of financial upgradation under the SCPS, there shall be no change in grade pay as granted under.
They're all in my favor.
Mr. Purkar, so better you obtain instruction and
Yes, sir.
let this court know in the next week.
Let it come after vacation.
Vacation.
Yes.
Okay.
And I will take inspection. Madam.
Heard Mr. Purkar, learned counsel for the petitioner, Mr. B. Sharma, learned standing counsel for the AG, and Ms. N. Fokon for respondent number.
Other respondents.
You are for? Ms. Boro for 8. P and 9. P and 9. 1, 2, 4, 5, and 6. Person 2, the order dated 24/11/2025. Mr. Sharma has obtained written instruction and placed the same before this court. And on the basis of the same, he submits that the ACPS does not envisage any additional increment. And it only envisages placement in the immediate next higher grade pay within the existing pay band of the employee in the hierarchy of the revised pay structure. And as such, from 1/7/2010, while the pay of the petitioner, official pay of the petitioner was 20,730, his grade pay was granted at the rate of rupees 4,500. And after the grant of ACP, his pay band remains same, that is 20,730, but his grade pay is enhanced to rupees 4,600. At this instance, Mr. Purkar, learned counsel for the petitioner submits that the matter may be listed after the vacation so as to enable him to obtain instruction. Where allowed, recessal list the matter immediately after reopening of the vacation. The instruction produced before the court today by Mr. Sharma shall be marked as Annexer A, B, A and B, and be tagged with the record.
Provide another copy.
Okay. Okay.
Well, it may come on 7th of January.
Perfectly.
After then, my lord, after behold, then my lord at 20. Obligation. Obligation.
May I pray to kindly pick up the matter in second half, lordship, kindly lordship.
Okay.
Here instruction is not received, my lord.
That is right, but there are some facts which Mr. Huya will inform this court, lordship. That is with some. That is all, that is correct.
No, no, second time. Second time.
Yes, lordship. Okay.
Lord, I'm sorry, my lord, I'm mentioning at this hour. My lord, as regards item 27, Mr. Brijesh Sharma, my lord,
Hmm.
I'm appearing on his behalf. He has some health issues suddenly, my lord. So he left the court, my lord.
Sharma.
Sharma, my lord. So matter can be adjourned and take up. My lord.
Okay. Mr. A.R. Bhuiya, Learned Counsel, appearing on behalf of Mr. B. Sharma, Learned Counsel for the provision.
27 to.
Submits that on account of some emergency, Mr. Sharma left the court and he pressed for listing the matter. When?
Next week.
Next week. Fair allot.
Obliged.
To be spoken to, number 36 at 2 p.m.
Where is Mr. Solia? Mr. Bora, there was an order of this court to file an affidavit by the finance department.
Yes, ma'am.
So you have not pointed it out at the time of hearing. Mr. Solia, there was a direction of this court dated 29/11/2024 to file an affidavit as the prayer for regularization of service of the petitioner was rejected by the ARTP and PG department
Yes,
and
sir.
finance department.
Yes, sir.
So why the affidavit has not been filed for last 1 year?
We had filed the affidavit.
When? Month of April.
Yes, Lord.
Respondent number 8. Finance department. Page number 96. From 100.
96 Lordship, as per my.
Yes, but it simply refers to the office note of the Administrative Reform, Training, Pension and Public Grievance Department. But where is that office note?
Lordship, here in the
You
page,
come to page number 98, paragraph number 4.
Proposal, Lordship, we received a proposal, Lordship.
Hmm.
And that proposal, Lordship, it was sent to us for our views, Lordship.
Hmm.
So in that view, Lordship, we have annexed in page number 100 of our affidavit, Lordship.
Page number 100.
Yes, Lordship. And then it was endorsed back to the education department, Lordship.
No, in fact, this is your endorsement.
Yes, Lordship.
But where is the endorsement of the that administrative reform department?
Lordship, here in our enforcement, we have received, finance department regrets the proposal of the education department. As per the views of ARTPPG department, and which states that there are no such rules in Assam Service Pension Rules 93 so and so regarding payment of pension and pensionary benefits to the employees under ad hoc appointment unless their services are required. This has the approval of the commissioner. This file was endorsed to us.
No, that's all right. But that endorsement is definitely there.
Lordship, here, the this is our endorsement, Lordship, on the basis of the views that we received from the.
No, therefore I am asking you, where is that endorsement, original endorsement? This is you have quoted.
Yes, Lordship, we had received an e-file, Lordship,
Hmm.
where the proposal for regularization of the petitioner was forwarded.
Hmm.
Lordship, we had endorsed the file back to the education department.
Hmm.
That is all, on which we were arguing upon, since we had also rejected it, and on the basis that the education department said this cannot be done because of this end of ours. We had endorsed the file back to the education department. They had only sent a proposal seeking our views whether regularization can be done. And if we had given the necessary approval.
No, you tell me, is there any standing counsel for the ARTPPG department? Government.
Yes, sir. Respondent number.
Respondent number?
Number 2.
Respondent 57 is the affidavit filed by the AG. Respondent number 7.
Who is Pension and Public Grievance Department? Lordship?
57 is the affidavit of AG. As per index of the section.
Respondent number 2.
27. 27.
22nd May. Lordship, 2025.
No, here you see the strength of the department is Department of School Education was advised to obtain the views of the personnel department and the finance department. Since the matter of regularization of service does not come under purview of ARTP and PG department. So where do you got it, Mr. Soleha?
No, Lordship, there is an affidavit filed by the respondent number 2, Lordship. That is The Joint Secretary
Yes.
ARTPG Department, Lordship. Here in the affidavit, they have stated.
Where?
Here, this copy, Lordship, that's page 58.
Here it is 102. Okay,
Yes.
all right.
Lordship, here in the last paragraph, they have stated, in this regard, Department of School Education was advised to obtain the views of personal department.
Hmm.
This was informed to the School Education Department, Lordship. And the Finance Department, since the matter of regularization does not come under the purview of ART PPG Department wide so and so letter.
Hmm.
So, here,
But your endorsement is quite different
no, Lordship,
from
here-
their affidavit.
No, Lordship, here
Hmm.
there was consultation, Lordship, and the endorsement of Lordship sees. Our endorsement is, Finance Department regrets the proposal of School Education Department as per the views of ARTPG endorsement, which states that there are no such rules. So and so, and this has the, there are no rules in Assam Pension Rule 1969 regarding payment of pension and pension benefits to the employees under ad hoc appointment unless their services are regularized.
Where it is mentioned.
Lordship, here, as per the views of ARTPG, Lordship, only the views regarding the views of the personal department, we are not aware. This was in consultation. Lordship, we had rejected the claim of the petitioner. That is all. And then here,
No. In the endorsement,
yes,
it has been mentioned that the ARTP department has.
in their views, Lordship.
Yes. There is no service rule for province for regularization. Where it is stated.
It's stated, Lordship, but
Then where do you got it?
Lordship, this was, Lordship, this has been indicated by the department, so they must have their
No,
internal communication. But in consultation with the ARTP,
No.
we had
In consultation means.
If Lordship wants me, Lordship, I can produce the views of the ARTPG on the basis of which I can produce that if, because that clearly stated that. If Lordship wants me to furnish that document.
No,
I
the
can-
basis of your affidavit is that they have regretted the proposal.
Yes, Lordship.
But in the affidavit, they have stated that no, it is not within their purview.
The part of regularization is not there, Lordship, but this in consultation, they just give the view that this is the stand, Lordship. Here, they are stating that regularization they cannot do. Pension and Lordship, from my.
You see, you have mentioned it as within inverted comma. There are no such rule in service.
Yes.
Assam Services Pension Rule 1969. Or office memorandum notification regarding payment of pension and pensionary benefits to the employees under ad hoc appointment unless their services are regularized.
Yes, sir.
So wherein in which part of their affidavit they have expressed it?
No, their affidavit, they might have not, Lordship, they might have not have got it on record. I can present the document on what basis from the ARTPG this endorsement came from. I can produce that.
Day after tomorrow.
Lordship may grant me 3 days on Thursday, Lordship, 2 days.
Thursday. Okay. Heard Mr. Bora, learned counsel for the petitioner, and also heard Mr. P. N. Sharma, learned standing counsel for the respondent in elementary education department. Mr. Soleha, learned standing counsel for the respondent in finance department. Mr. Learned counsel for the respondent number 7 AZ, and Ms. Pukon for respondent number 2 and 6. The affidavit filed by the finance department indicates that the proposal for regularization of service of the petitioner was rejected on the ground that there are no such rule. As per views of ARTPPG department, which states that within inverted comma, there are no such rules in Assam Services Pension Rule 1969 or Office Memorandum struck notification regarding payment of pension and pensionary benefit to the employees under ad hoc appointment unless their services are regularized. Full stop, inverted comma close. But it appears that the respondent number 2 the Joint Secretary. No, respondent number 2 has filed one affidavit on 29 May 2025, wherein the department has taken a stand that the Department of School Education was advised to obtain the views of Personnel Department and Finance Department since the matter of regularization of service does not come under the purview of ARTP and PG Department. By ECF number 435210 dated 24/1/2024. And the endorsement of the ARTP and PG Department, which is quoted in the annexure number A, enclosed with the affidavit in opposition filed the Finance Department. The said endorsement is found to be missing in the in the affidavit filed by the Department of ARTP and PG. Accordingly, Mr. Soliha Learned, Standing Counsel for the Finance Department, is directed to produce the relevant file before this court on Thursday.
That's the, basically the endorsement of the AR, yes. The endorsement.
There is for admission.
May I, please, Your Lordship?
Yes.
Lord, when the service of the petitioner, my lord, has been provincialized, he was provincialized as a, my lord, suspected superintendent of a Silchar senior madrasa at that relevant period of time, my lord. Now, my lord, once my service had been provincialized, my lord, thereafter, my lord, no departmental proceeding had been initiated. Neither, my lord, any charge memo or, my lord, my suspension had been extended.
Where is the suspension?
Yes, yes, my lord. My lord may be pleased to find, my lord, is the, my lord, Fakhruddin Loskor, page 39, my lord, may kindly have a look, my lord. We have also made a type copy of it, my lord. Page 39, my lord, the present.
No,
petition.
Order by which
No,
you have
my
been
lord,
placed under
Yes,
suspension.
yes, my lord, what has happened, my lord, prior to this order, my lord, I have been placed under suspension by the managing committee of a Bangalore state, my lord. Now, by treating me as a suspended superintendent, my lord, my particulars had been processed for the purpose of provincialization, and accordingly, my lord, the government had provincialized my service as a suspended superintendent, my lord. Peruse the order at page 39. My lord, the page 39 at the second table, the services of the following incumbents have been provincialized. My lord, got it, my lord. Page 39, second table I am reading, my lord.
Yes.
Services of the following incumbents have been provincialized with effect from 1/1/2013. The above mentioned allotted posts created by government letter number dated so and so, name of incumbent, Fakhruddin Laskar, superintendent, so and so, Milord, under suspension, so and so, had been shown as under suspension, Milord. At this moment, from this order, Milord, they have not proceeded further, Milord. Now my suspension had been revoked, no salary, nothing. Now, Milord, I am a kidney patient and going to be retired, Milord, recently. I am at this stage, Milord, around 59 years of age, Milord. 57 years of age, Milord. So therefore, Milord, though the notice had been issued, but the Milord, there is no any Milord response as I have received yet, Milord. Milord, at least as I am suspended, Milord, I am at least entitled to the subsistence allowance, Milord. That they can provide, Milord. I have not found, Milord.
Now they will take a stand that we have not placed him under suspension. It is the managing committee.
That is correct. But that suspension has been regularized by the government by this order, Milord. That my limited
No,
understanding.
suspension has not been regularized.
No, no,
What
no,
is
no.
regularized is your service.
No, Milord, I am not, the term, the suspension period, I am not saying, Milord. The suspension by a private body has been approved by government, Milord. By a this order, if I am not wrongly understood, Milord.
No,
therefore it
where it is mentioned that
The-
his
the-
suspension order is approved.
No. Approval means, Milord, from the interpretation of this provincialization order, it says, Milord, because the very line says the services of the following incumbents have been provincialized with effect from so and so against the above mentioned allotted post created by government letter number dated so and so. So, Milord, as my service had also been provincialized as treating myself as an under suspended employee, Milord, so therefore it has the approval of the government. The private entity's action has been, Milord, approved by the government, Milord. So therefore, Milord, now I will come under the purview of the protection under the Assam Services Discipline and Appeal Rules as well as the fundamental and subsidiary rules also, Milord.
This order was passed on 27th of December 2013.
2013, I am
What
hoping.
happened?
Now, Milord, this
No,
school has.
why you have not approved earlier?
Milord, I did approach earlier, Milord. In some cases had also been filed, but Milord, this issue has never been raised in those petitions, Milord. And another petition is pending, Milord, before this honorable court also in proceeding. But, Milord, as I have not retired till date, Milord, then they can take a call, Milord, on this issue, Milord. Condition, Milord, really pathetic. I have gone through physically, Milord.
No, that's all right.
My
It's pathetic, but who is responsible for not approaching this court for last
11 years, Milord.
Yes.
That is correct, Milord. But, my Lord, it is a continuous injustice with me, Milord. Therefore, that delay, my Lord, may not
The
be a
respondent
fatal.
will also take a stand that in view of there is one decision, he cannot claim the arrear salary. It is beyond 3 years.
I am not the arrear salary, Milord, at this moment, Milord. That is correct, Milord. Beyond 3 years, there is a bar as per the division bench order of our court, Milord. But the issue is that, Milord, here is a case of suspension benefits, Milord. Whether a person, Milord, can be placed under sometime, Milord, some people has been not working or debarred from the service. Now, it is not my intention, Milord. The government has debarred me from attending my duties by this order, Milord. It's a peculiar situation, Milord.
Mr. Sharma, why the informations or instructions are not available? Where is your affidavit?
No,
Yet to come, my lord, and moreover, my lord, he was suspended by the private body, that is managing committee at the answer stage, my lord.
No,
No.
maybe, but no, Mr. Sharma,
was disposed on only when on 11 in the month of November 2024, and thereafter he has come. So sometime this may be granted so that I can take the.
No, Mr. Sharma, you see, by this order dated 27th of December 2013, his service has been provincialized.
Yes.
So
On
he
suspension.
comes under the purview of the that act. 2011 Act.
2011 Act.
Mal.
So he is entitled to the benefit of a government servant. He is entitled to this subsistence allowance. That is his fundamental right. That
So, my
M.
lord-
Paul Anthony decision.
Or what is going on in this matter, my lord. So I have to take instruction from the department that they have taken any steps or what happened to them. So my lord, kindly give us some time so that I can take that obtain instruction from them. The school was provisionalized 1/1/2013.
So you see, this order was passed on 7/3/2025. Almost 10 months back. Why the instructions are not available? Why your affidavit is not ready? Mr. A.R. Bhuiya, learned counsel for the petitioner, and Mr. U. Sharma, learned standing counsel for the respondent in Secondary Education Department. Mr. Sharma submits that he has not received any instruction regarding the stand of the department in this matter, and he prays for granting him some time. On the other hand, Mr. Bhuiya, learned counsel for the petitioner, submits that the service of the petitioner was provincialized as superintendent under suspension by order dated 27th of December 2013. And since then, the petitioner has neither been receiving any salary nor receiving the subsistence allowance, and also he is not receiving any benefit of the provincialization of his service. Though on the strength of the order dated 27th of December 2013, he becomes a government servant. In view of the pair being made by Mr. Sharma, the matter stands adjourned to be listed on before vacation. 18th. So as to enable Mr. Sharma to obtain instruction. And in the meantime, the respondent in Secondary Education Department shall take necessary step to review the suspension order of the petitioner and also to release the subsistence allowance the petitioner, which the petitioner is entitled to in view of the order dated 27th of December 2013. Release the matter on 18th.
Mal.
You ask them to release the suspension or subsistence allowance.
A copy of order may be
A copy of the order be furnished to Mr. Sharma during the course of the day.
Obliged, highly obliged.
So, perhaps they have filed a reply affidavit. On record certain document. Reply.
When? After 2 weeks, it will be vacation. Vacation will start
Vacation starts
from
8th of January, 9th of January. 8th or 9th.
7th of January.
7th of January.
Or 6th, maybe.
Heard Ms. Sharma, learned counsel for the petitioner. To Mr. Sharma for respondent number 6 and 7. And Mr. P. N. Anna, learned counsel appearing on behalf of Mr. S. Sutia, learned standing counsel for the respondent in Elementary Education Department. Mr. Sharma submits that Ms. Sutia, though present in the first part of the day in the court, she left for home due to some urgency, and on account of the same, he pressed for listing the matter immediately after reopening of the vacation. There is allowed recessal list the matter on 6.
May I please? My lord, during the investigation of this case, my lord, earlier also my lord, this petitioner approached before your lordship. Then it was my lord declined, my lord. Now, my lord, charge sheet has been submitted, my lord, and the trial is also started, my lord.
Pardon?
Now, my lord, in the meantime, my lord, charge sheet has been submitted and trial of the case is begun, my lord.
When
And,
charge sheet was submitted?
But the charge sheet was submitted. My lord, this, I have annexed, my lord, itself, my lord, page 30/12/2023. Thirty-five annexure 5, my lord, I have annexed, my lord. This, my lord, this case is, my lord, filed, my lord, it is all our family members, my lord. Even, my lord, this informant made, my lord, accused number 2 his own father, my lord. And accused number 3 to rest his own brother, my lord. And petition number 1, because lordship, who is accused number 1 is his own uncle, my lord. Only to, my lord, take land, my lord. And in the meantime, another, my lord, mitigating aspect of this matter, my lord, as per allegation, this girl was, my lord, 17 years plus age, my lord, in the date of, my lord, FIR.
Counsel for the contempt now. Mr. Mohanto, learned counsel for the petitioner, submits that the respondent contemptor has filed an additional affidavit, and he may be granted 2 days time to file his response. Where allowed recessal list the matter in the next week?
On Monday.
Covered.
Yes.
Monday.
That's fine.
Okay, as parted. And here,
No affidavit has been filed in my case, basically.
Common judgment.
common.
Stand will cover them.
Okay,
So that copy may be served, my lord.
I'll serve it.
okay. Mr. Decker, learned counsel for the petitioner, and Mr. Kosik, learned counsel for the contemptor. Mr. Kosik submits that this item number 23 and 24 are
Rising out
filed-
of a common.
arising out of the same common order, and the affidavit filing item number 24 will serve the interest of the department in item number 23 also. At this instance, Mr. Decker submits that he has not been furnished with a copy of the additional affidavit. At this instance, Mr. Kosik undertakes to furnish a copy of the same to Mr. Decker during the course of the day. List on Monday.
That's okay.
Look, in this case, from the last day, with the letter dated 1/12/2025. Regarding the proposal being sent to the finance department for appointment method. So the finance department returned the file on 4/12/2025, citing a clarification in respect of the date of effect of the order of the service of the petitioner. 5/12, we have responded back and returned the file to the finance department again. Now it is pending before the finance department. They raised a query with regard to what should be the date of effect. And as per the opinion given, though the date of recommendation was later, but as there was a delay, we have suggested to give the effect from the date of order of this control. And accordingly, it has been ensured to the finance department again on 5/12/2025.
You furnish a copy to Mr. Soliha?
I give him a copy.
Soliha, you obtain instruction. Though you are not a party here.
Yes, sir.
He is very.
Heard Mr. A.U. Ahmed, Learned Counsel for the petitioner. Mr. B. Kosik, Learned Counsel for the complainant. Mr. Kosik submits that though the file was earlier endorsed to the finance department, the finance department has returned the same on 4/12/2025, seeking some clarification. And accordingly, the clarification has been furnished to the finance department by re-endorsing the file on 5/12/2025. And the same has not yet been received back by the contender number 1. Accordingly, Mr. Soliha, Learned Counsel for the Finance Department, who is present in the court in respect to some other matters, is directed to obtain the status of the file number E461922, which was forwarded to the finance department on 5/12, which was re-endorsed to the finance department on 5/12/2025. This is a list the matter on. When
Somewhere in January, give them time to process also. Give them some time.
no, unless the matter come back from your department to his department, how can he will proceed?
But that is why I'm asking for first week of January.
They will have to give the concurrence and
Yes, sir.
approval.
Yeah, only the concurrence.
Yes, sir. So, some verification time may be done.
No. Next week, before vacation.
But last day of the.
But it's so many times they have taken already.
We have to verify
Okay.
lot of.
Wednesday, next week.
Next Wednesday.
The letter produced before the court today shall be marked as F and be tagged with the record.
And here, some proposal have sent to the finance department for their concurrence minor.
For yes, sir.
Soliha, Mr. Can you call Mr. Soliha? Heard. Mr. R. Islam, Learned Counsel for the petitioner, and Mr. Ayub Sharma, Learned Standing Counsel for the, yes, standing and Council for the Secondary Education Department. Mr. Solia, another matter is there. During the course of deliberation, Mr. Sharma has produced one letter of the Joint Secretary to the Government of Assam Department of School Education. And on the basis of the said letter, he submits that the financial sanction proposal has been moved to the Finance Department for necessary concurrence through FinAssam portal. And after getting concurrence from the Finance Department, the department will take further step accordingly. Accordingly, Mr. Soleha Learned, Standing Counsel for the Finance Department, is directed to obtain instruction regarding the letter number E-714615 of stroke 25 dated 21/11/2025. And appraise this court on next Monday.
But Wednesday.
Wednesday.
Okay. By then maybe concurrence may already be given also. Wednesday.
Okay.
Blessed.
Recessal is the matter on Wednesday. So as to enable Mr. Solia to obtain instruction.
Okay, here, after the school has submitted the proposal to the pension department. Then from pension department returned back on the original records and requested the inspector school to meet the proposal to the appropriate authority. That is the Lordship, Registrar Assam University. So according to the inspector of school on 26/11, had submitted the proposal to the Registrar Assam University on 26/11/2025. Now the Registrar Assam University
Take further step.
Yes.
Yes,
Pension of products.
whether the proposal has been received by the Assam University?
The pension was returned to the petition. The petition pension was given to the school of inspector of school. That is the instruction that I have received on 1/12.
Earlier, that was returned and we have taken return with the finance.
That is the instruction I have.
Check with the law is that.
So you furnish a copy of
Yes,
this
yes.
letter to her. None appears for the petitioner on call. How about Mr. SMT Sisti, Learned Counsel for the respondent number 2 and 6, and Mr. Devi for respondent number 7, and Ms. Upadhyay, Learned Counsel, appearing on behalf of Mr. S.C. Kayal, Learned Standing Counsel for the respondent number 1. Present. Mr. Sisti has produced one letter dated 26/11/2025, issued by the Inspector of School, CDC Silsor, to the Registrar Assam University. And on the basis of the said letter, Mr. Sisti submits that the inspector has already submitted the original service book number 1 along with pension papers and other relevant documents in respect of Dr. Sujata Bhattacharya, ex-subject teacher, Yudhishthir Saha High School, Behra Bazar, and retired senior technical assistant within the Life Science of Assam University. For granting pension and retirement benefit for the entire length of service rendered by the petitioner as claimed by her. Ms. Upaidya submits that she has no instruction in respect of the said letter. Accordingly, Mr. Sisti is directed to furnish a copy of the letter dated 26/11/2025 to Ms. Upaidya during the course of the day, so that she may obtain the status of the said letter and appraise this court on next Monday.
I've already submitted.
The letter produced before the court today shall be marked as Annexure A and be tagged with the report.
Last order also. Almost 4 years, they're not yes and
Time or the instruction. Actually, what is it now? Last occasion I have submitted one instruction. The register has asked the auditor to send a proper auditor has submitted the proper proposal in proper form. Now after the audit, review the audit now it's pending before the FA financial pressure. If the clear then
Heard Mr. Gogoi, learned counsel for the petitioner, and Mr. Das, learned standing counsel for the Higher Education Department. Mr. Das submits that the matter is being processed and now it is lying with the FA, Financial Advisor of the Directorate. And he prays for listing the matter after 2 weeks. After 2 weeks, pair allowed. In the meantime, Mr. Das says, shall instruct the respondents to complete the entire process. Based on 6th of January 2026.
Even on last occasion, I had submitted an affidavit lordship that the hearing is scheduled to be held on 28/11. That was hearing was held and report came lordship. The report the director is going to the compliance order very soon lordship. I by this end of this week lordship that compliance will come. So Monday lordship can fix it lordship and
Monday.
yes.
Heard Mr. Khandekar, learned counsel for the petitioner, and Mr.
He has some
This is
difficulty
the
Wednesday.
learned counsel for the contender. Mr. Sisti submits that the director will comply with the order of this court by the end of this week.
Yes.
And he prays for listing the matter on Wednesday. Wednesday. Okay. Bear allowed. Mr. Sisti shall produce the compliance order before this court on.
Yes.
I'm. May it please your lordship.
Case of last directed to some instruction to instruction emitted kindly time frame. Regarding withdrawal post.
Heard Mr. S. J. Sharma, learned counsel for the petitioner, and Mr. S. Das, learned standing counsel for the respondent in higher education, for the contender. For the contender, Mr. Das submits that instructions are still awaited and tries for listing the matter. After? No. Next week. After 2 weeks, however, Mr. Sharma, Mr. Das is granted 1 week time. This shall list the matter on 17th. So as to enable Mr. Das to obtain up to date instruction.
Always.
Your Honor, possible for the time being. Is the other court.
Who will appear? Who will appear?
Advocate MH Laskar.
Pardon? Mr. Locker, you furnish a copy to
I just provided.
Learned Counsel for the petitioner, Mr. P.K. Bora, Learned Counsel for the contemner. Mr. Bora has produced one letter of the Secretary to the Gupta Assam Department of School Education dated 7/12/2025. And on the strength of the said letter, he submits that compliance process has been initiated and some time may be granted to accomplish the same. Accordingly, taking note of the submission of Mr. Bora, Learned Counsel for the petitioner, the matter stands adjourned to be listed last week.
After first week of January, I need some time, that is why. They have take 15 days. Here,
First week. This is at least the matter on 6th of January. The letter produced before the court today shall be marked as Annexure C and be taken to the record.
Obliged.
34 Lothian came to the complaint order. That order has been, that so-called notice has been kept in abeyance. Already paid that salary for that 2 months notice. Only that so-called notice are supposed to be in abeyance. We have withdrawn. It is supposed to be notice kept in abeyance.
Will give a reply.
So what was the direction of this court?
Yes, get to direction, yes.
So, there was a order that was passed on the 3rd of the beginning of this year, 3rd of January. And it said no coercive steps to be taken against the petitioner. In the face of that order, there were 2 separate actions that were initiated. The first action was a fresh show cause notice was issued on the basis of the same grounds that was put to challenge in the connected writ petition. So that was the first strike. Secondly, the salary was stopped. So these are 2 violations of the same order that takes place. So that is why this contempt.
So salary has been released now?
Salary has been released.
And the so-called notice has been kept in abeyance?
Two things, two submissions, Your Honor, very shortly. Firstly, this has been kept in abeyance. It's not been quashed. Meaning
Basically is going on. All this content against the interim order. So till the repetition is before the we are kept in abeyance. There's no question of getting process. Honorable court, this is that it should be quashed.
No.
Repetition is still pending.
My submission is a little different. My submission is that in a contempt proceeding,
It's a contempt proceeding.
in that proceeding of this nature, there are 2 separate actions that take place. The first action is that of punishment. Whether a person has committed a contempt or not is the first thing to be seen. A counter affidavit has not come. So are they admitting their contempt? That has to be dealt with first. And the second.
No.
Your Honor, share the judgment. And the second part is purging of the contempt.
No. They have not filed their affidavit. It does not mean that they have admitted.
I'm not saying it's deemed. I'm just saying, is that their case? Because at the end of the day, what is relevant here is for them to file a counter. That is my point.
No, you see, the allegation is non-compliance of the interim order passed by this court.
Please, Your Honor. Absolutely.
Yes, the salary has been paid to you.
Yes, Your Honor.
One is complied with, and this proceeding has been kept in abeyance. That has also been complied with.
So the phrase here, Your Honor, that technically this is purging of the contempt. Because the law is that once a contempt is issued, once a
No, the direction of this court is complied with.
the
Because,
original directions, yes.
Whether
Yes, yes.
the charges will be quashed or not, that will be looked into the main writ petition.
Respectfully, Your Honor, because the very initiation of the action has to go. Because the original action that they took, that I put to challenge in my writ petition, that still stands. So what I'm to understand is there are two actions against me to take. One has been stayed by the Honorable High Court by the 3rd of January order, and the second one they
No,
put in
but
abeyance.
you see, what was the direction?
Please, Your Honor.
Not to coercive action.
Coercive action.
Yes.
And is it clarified what is coercive action?
No, Your Honor,
Is it clarified in the order?
no, Your Honor, it's not been clarified in the order, but
You please answer my query.
no,
Is it clarified what is coercive action?
case is that this
No. First answer my question.
maybe have the order once.
Yes.
I think it, because the order is very simple, no coercive action. So the clarification that the Honorable High Court has given as to what would be the coercive action, but my submission is that initiation of a show cause notice on the same grounds would be the coercive action. That's my submission. If they have a different submission, I'm open to that.
No, they have already kept it abeyance.
Yes.
Contempt proceeding is a court and a contender. Their duty is to submit before the court. Now we have complied. What remains, Lordship? Let the petition continue, Lordship.
Your Honor, I share the judgment. Your Honor, may I please have para 24 of the judgment. Because at the end of the day, I'm representing a lower primary LP school teacher who has been traumatized by this entire what has been going on. Because at the end of the day, she faces an action, she comes to court, gets a stay of orders, faces another action, comes back to court, and then has a salary stop. Magically, the salary stops and magically the salary begins. Surely there has to be some oversight over such conduct. Taking away a person's salary is very grave. Your Honor, I have para 24 at internal page 660.
No, first show me the order.
Yes, Your Honor. Page 89, Your Honor.
But it is an omnibus order.
Yes, Your Honor. I'm disputing that.
Then?
But this would still be contempt. In my
Contempt.
Yes, because
better you go to another court.
It is whatever is a contempt. We have already complied, Lordship, that nothing remains unnecessary, Lordship.
Heard, Mr. Your good name?
Please let me report my judgment.
Sorry.
Just 2 minutes, Your Honor. May I actually...
No. What is your name?
Didas, Your Honor.
Learned counsel for the petitioner, Mr. S.N.T. Sisti. Learned counsel for the respondent. Contender. Rest shall list the matter before another bench without me.
My name is shown, Lordship. Though I have filed local number, my name is not shown in the court list. Lordship, that
Okay.
Yes.
Mr. The name of Mr. Sisti, the counsel for the complainer shall be reflected in the counsel list. by the
Oblige, Your
registrar.
Honor.
Next item.
Deeply oblige, Your Honor.
May I please? So I am in charge of a college as well as I am a tutor. Lordship. The writ petitioners, so who are one is RTI activist and other is ex-student of the college, has filed this writ petition challenging my appointment as a principal in charge in the year that took place in the year 2013, and as well as provisionalization of my service, Lordship. And during the pendency of the writ petition, Lordship, the department has issued notices for hearing on the writ petition itself. That is why I am.
Pardon?
While the court is in session of the writ petition, the Director of Higher Education has issued a notice to me to attend the hearing on the same writ petition, Lordship.
Yes, Mr. Das. While the matter is sub judice before the court, how can you start a parallel proceeding?
Factual dispute. The factual dispute is that petitioner has challenged.
No, petitioner has no locus standi at all. Lordship. I am not going to the merit, but one is Lordship think about RTI activists and other is ex-student. They have approached this court. Writ petition itself is not maintainable and that is liable to be dismissed with cost, Lordship. They are busybodies, in fact.
That is, but that is locus of the petitioner. The theory is regarding the factual dispute. That's why to ascertain the factual dispute, he has been called for hearing. Nothing like that.
No, court can take care of it, Lordship. The petition is pending before the court.
No, this IA is for what purpose?
Yeah, for saying that hearing process initiated by the authorities. Next date is, Lordship, we find at page. Today we have filed an additional affidavit that is on, it is scheduled to be held on 10/12/2025, Lordship. Last page of the additional affidavit. That is page number 38 in the IA. After filing of the IA, they have again
Mr.
issued.
Das, you ask the respondent to stay the proceeding. They cannot initiate parallel proceeding while the matter is, this court is insisting of the matter. There are several decisions of this court.
But my humble submission, there is judgment of this Indian Bank Abdul Ghaffur Mandal. Which says that this kind of disputes is the educational tribunal is the appropriate forum to.
No, that we will consider in the writ petition, main writ petition. Today we are on the IA.
Yes.
You ask them to stay the proceeding.
If you call on the president governing body and principal in there.
Yes, I am the principal. I am the respondent number.
I'm party to the respondent also.
No, the hearing on writ petition, that is the address. Lordship will find page 27, the first letter. Hearing on 17/11/2025, inviting reference with the subject cited above, I am directed you to request and attend the office of the Director of Higher Education Assam on 17/11/25 at 11 AM without fail, along with all original documents in connection with writ petition number Iman filed by Horis Pegut, and the writ which document they have called, even I am not the petitioner, I am the respondent number. The notice were issued to the president and principal. Who is the respondent? Whatever document they have related should be with the petitioners. Is left side. Oh, we have respondent number.
Okay.
One thing is that this notice has been issued to president and the principal. This principal and principal asked to bring original documents regarding this petitioner and the
No, whatever may be the cause, you cannot start a parallel proceeding after filing of the writ petition. Heard, Mr.
You doctor.
B. Doctor, learned counsel for the petitioner, Mr. No, applicant.
Applicant.
Mr. S. Plus, learned counsel for the respondent, opposite party number. One and two.
1 and 2.
1, 2, and 3. Inspector of school.
1 and 2, Lordship.
1 and 2. And madam, you are not a party here.
No. No, here she is respondent, Lordship.
Respondent number? No, in IA.
6 and 7, Lordship.
6 and 7.
7.
6 and 7. This interlocutory application is referred by the applicant who is staying, suspending the hearing initiated by the respondent number 2 in pursuance to the letter number PC HE CC 17 2025 22 dated 22/10/2025 issued by the Joint Director of Higher Education, Assam, till disposal of the disposal of the writ petition number 1830 of 2021. Mr. Datta, learned counsel for the applicant, submits that WPC number 1830 of 2021 was initiated by one
RTA activist, the ex-student of the adult class. As per their
one Horace Pego,
yes,
who is the
RTA activist.
RTI activist, and by one Umesh Pego, who is
He is ex-student of the college.
ex-student of the college, challenging the appointment of the petitioner as principal.
As principal as well as
Challenging the appointment of respondent number 5.
yes, challenging the appointment of the respondent number 6. That is
Respondent number 6
yes,
as a principal,
as principal in charge.
GRL College,
Yes, and also provincialization of his teacher.
and also provincialization of his service as tutor,
Assistant professor.
tutor stroke assistant professor. Mr. Dotto submits that while the said writ petition is pending before this court for adjudication, the Director, Secondary Education has started a parallel proceeding, which the Director is not entitled to, as this court is insisting of the matter. And in that view of the matter, the proceeding initiated by the Director is required to be stayed. Accordingly, taking note of the submission of learned counsel for both the parties, and also considering the facts and circumstances on the record,
Next date
the
10, 12.
hearing, the hearing initiated by the Director, respondent number 2, in persons to the letter number PC HE CC 17 2025 22 dated 22/10/2025 stands state till disposal of the WPC number 1830 of 2021.
Now the present Lordship, refix on 10/12/2025. Lordship.
And refix on 10/12/2025
2025. And
stands state till disposal of the writ petition.
later the 26 November
You
2000.
give the number to the
Yes.
postmaster.
I would like to-
In terms of this IA stands closed.